I mention on matter, no matter, my lord, that regarding the my Lord Justice Mousumi Bhattacharya. My lord, I have come with the list of the today's list. My lord, that is the first two matter for judgment and another 105 matter fixed matter. My lord, my question is that, my lord, if the matter is fixed by Her Lordship's Delhi, my lord, why the general public will go? So what my client will mention on matter, no matter, my lord, that regarding what my client will, my lord, every matter is urgent, my lord. My lord, I have come with the list of this.
Now, what do you want, sir?
My lord, I want your lordship's big attention regarding that bench, because we are seeing in the newspaper that the two matter has been shifted to other bench. My matter is pending last 1 year. 1 year. Lordship, kindly see page 128.
No, whatever.
My Lord Justice Mousumi Bhattacharya.
No. Whatever
Lordship fix 105 matter as fixed matters.
Whatever you want, you please put it in writing and hand it.
But what to?
If you want any mentioning to be done,
What to write, my Lord? Well, I shall write.
Yes, whatever is your grievance, you write.
Before Lordships. Before your Lordships.
You give it to the secretary.
My Lord. Grateful, my Lord.
My Lord, 26 April, my Lord. My Lord, pass the order, only correction of the cost title, my Lord.
Lordship, may I be permitted to mention?
Regarding section 153 of the Income Tax Act, my Lord, cost title wrongly uploaded, my Lord.
This matter has been listed under the caption to be mentioned. It is pointed out that there are certain typographical errors in the case number, in the cost title, and the names of the advocates. The same shall be corrected, and this order shall form part of the order dated 26th April 2023. The correction
Grateful.
is already made.
May I have your lordship's kind leave to mention a matter, my lord? I'm praying for leave to file this appeal with a photocopy of the order, my lord. We don't have the certified copy.
Lord, under grave order,
Grateful to your lord.
and with great respect, my matter previously might have directed, it will appear in the supplementary list.
It's appellate side matter or original side?
Appellate.
Appellate side today, Monday, you please.
My I bow down here. I bow down. But my lord previously on oath, statement on oath from the bar, being the member, my lord directed previously.
All right, you give this, you give it to this.
Oh, yes, my lord, deep lord. My lord, extreme margin, Vidyadhuri
You
river water.
give the letter to the AC.
Lordship, may I be permitted to mention, Lordship, one appellate side?
No, please say.
Have you served notice upon the other side? Mention after serving notice upon the other side.
Do it today.
Lordship, may I be permitted to mention, Lordship, one appellate side matter. In this matter, the private respondents in the appeal, Lordship, are without electricity due to pendency of the said.
Monday you give out the slip. Monday.
Lord, being placed under urgency, my lord, may I, my lord, mention this matter for obtaining leave of your lordship to move these matters urgently. My lord, I'll indicate the urgency very shortly. The respondent is the school. The primary respondent is the school who is letting out the premises in flagrant violation of all the laws in this respect commercially.
It will come tomorrow.
My lord, let that leave be granted, because otherwise.
File it, sir. You file the matter. If it is filed, fresh matters, you don't require mentioning. You already made it clear. Fresh matters will automatically come.
My lord, may I indicate the urgency? My lord,
What? You, without even filing it, you are mentioning. You please file it in the
my
department.
lord, the program is on day after tomorrow. And my lord, in the by the general rules, at least 48 hours needs to lapse before the matter can be listed. That is why I
should have moved earlier.
Lord, I have, my lord, very recently been able to understand this situation, and I have immediately, without, my lord.
No. For the default of the petitioner, we can't be blamed. So you file the matter. Let us see. Please call the list.
My lord, under grave urgency, may I be permitted to mention one matter for upgradation, my lord?
Appellate side.
Appellate
Monday.
Original side matter, item number 1. New application tax matters.
My lord, this is my appeal. My lord, there's a delay of 702 days.
You have filed your affidavit?
I want to file an appeal.
All right. We have heard so and so, so and so. At the request of the learned advocate for the respondent, matter stands adjourned by 4 weeks. By then, the respondent is at liberty to file affidavit in opposition to the condone delay petition. Reply in, if any, within the set time. List the matter on so and so.
हाँ? क्या सर्विस दे रहे तो
Item number 2,
Wait, please. Lord, it's that appeal, my lord, filed by the bank.
Lord, I
Mr.
appear for
Lord,
the respondent number 1.
Lord, on the last occasion, my lordship had directed, my lord, that if the parties could amicably settle the matter, my lord, that was the order. My lord, we tried, my lord, but no settlement, my lord, could be reached.
The bank
My
was
lord,
not
the minutes-
reasonable, hence the
Hey, let me complete. My lord, the minutes, my lord, of the meeting, my lord, it has been circulated to the petitioner as well.
Hmm.
My lord, will, if your lordship kindly takes this.
to settle the matter.
My lord, the petitioner says that I shall talk for any settlement only if the honorable single judge's order is complied with.
that manner or not, under
My
one.
learned friend has not had a look, my lord.
I haven't had a look. my
I've
lord.
just told him in the morning, my lord, so he's not
Okay.
had a chance to. my lord.
Then you please,
Kaitan gives me the
I will
copy. My lord takes it up next week. I will go
Alright.
through it and
um,
2 weeks later, my lord.
we have heard so and so. The learned senior advocate appearing for the respondent submitted that the issue based on which the Commissioner of Income Tax exercised jurisdiction under section 263 was the same issue on which the assessing officer reopened the assessment for the assessment years
2008-9 to 2011-12.
8-9 to 2011. And the reopening of the assessment in those years had been set aside in the appeal filed before the Commissioner of Income Tax Appeals, and those orders have attained the finality. If this position, as submitted by the learned senior counsel, is correct, then the subject issue, which is the issue which is subject matter of in this appeal, would no longer survive for consideration. And deciding the substantial question of law admitted for consideration would be an academic exercise. Let the copies of the relevant orders be furnished to the learned senior standing counsel for the appellant to enable the counsel to learned counsel to verify and make submissions.
But there's one more year, my lord, assessment 13-14, which is regular assessment, regular appeal, my lord.
In between you add, apart from that, it is submitted that in a regular assessment
For the
for
assessment.
the assessment year 2013-14, identical issue was raised by the assessing officer, and ultimately no addition.
And my lord, the relief was granted by the Commissioner of Appeals.
Identical issue was raised by the assessing officer and held against the assessee, and on appeal before the Commissioner of Income Tax Appeal, the said order was set aside, and such order of the Commissioner of Appeals, Commissioner of Income Tax Appeals, had attained finality.
I'm ready.
My lord is keeping it after
Vacation.
after vacation, my
Ah.
lord. Grateful.
Monthly list item number 26.
My lord, this matter is a very old matter
No.
relating to 1947 Central Excise Act. I need some instructions from the department. I haven't been able to actually
What is
speak to
the
them.
what is the matter?
Bengal Street.
You also don't.
He informed me that he will be doing this today.
Yes, my lord, I did inform him.
Oh, it was originally dismissed for default, restored.
Yes, they are restored.
Let's see if there's not.
In fact, I have spoken to the department so many times, nobody has been able to come.
They won't have papers. That's a problem.
Because I require some specific instructions on this matter.
Whether the tribunal was justified in allowing the appeal without ascertaining the factual position of actual utilization of input
Yes.
appropriate to be charged to the electric induction furnace.
Yes.
Factly workers.
Facts based. কোন পেটে আছে কিছু না। কোথায়?
The High Court. No, no.
Order.
পেপার বুকই নেই আমার কাছে ঠিক করে। My lord will also allow me, subject to my lord's pleasure, my lord, take a photocopy of this.
Photocopy of this.
of the paper.
Actually, that in your statement of facts,
Yes, my lord.
it is stated that a batch of appeals were allowed by the tribunal.
Yes, my lord.
And you need to verify whether in the other cases also you had filed an appeal.
I will do that, my lord. I will do that.
They had purchased steel from various suppliers, including Tata Steel,
Yes.
and whether that material was used in the, where is the order of the,
Order in original.
Order in original.
এটা তো আমার কাছে ঠিকমতোভাবে paper
Tribunal order টা বার করো।
Tribunal order টা বার
Order আছে।
tribunal order টা বার-
আরো
Sister. Sister order.
চেষ্টা করো।
it's a batch of 7 appeals,
Yes,
and you have filed only in one, Bengal Steel.
yes, my lord. So whether there are other appeals or not, that also I'm not aware. It may be possible that there are other appeals.
গোষ্ঠী আমরা ছিলাম সারোগি জেপি কর্তৃক ছিল স্থান চৌধুরী ছিল
তো কবেকার matter?
99 1999 order passed in 2000 But the duty demand was with respect to only Bengal Steel,
Okay.
and the others were imposed with penalties. As I find from the second page of the
Yes.
tribunal order, first paragraph.
Main appellant firm is Bengal
Hmm.
Steel Industries,
Industries.
engaged in the manufacture of alloy and non-alloy steel.
Like this issue is more or less covered. The issue was that they availed modified credit on the basis of documents where the sale Tisco, they had endorsed that no more. So Malak, this issue is
No,
more,
actually, tribunal granted relief on the extended period.
yes.
It has not, of course, it has examined the other issue. Ultimately, in para 16 of the order, it says that extended, there is no allegation of
Suppression of fact.
willful misstatement, collusion or suppression. Each of those acts require a conscious and deliberate. We'll dispose it of, sir, 1990 matter. Please see page para 16, page 28.
Yes, my lord. We find that there cannot be any misstatement or suppression where the SCC has
Attached.
and placed all the documents on the basis of which credit was taken by him before the revenue, which was also examined by the revenue. Accordingly, we hold that extended period was not available to the revenue and the demand is entitled to be on the extended period, my lord.
Entirely barred. Demand is entirely barred by limitation.
We'll dispose it of. Why to keep it pending? And as a age-old matter, 1990 matter.
My lord, these are all under the 1944 rules. I am not aware whether there would be any difference in the.
No,
in the-
we will not go into that aspect.
My lord.
We will say that on facts, the tribunal examined and found that there was nothing to indicate that there was a willful misstatement, collusion or suppression. And therefore, the extended period could not have been invoked.
এটাতে তো পাবো না, no. অনেকবার বলা হয়েছে। My lord.
This appeal, please take down, sir. this appeal filed by the revenue under section 35H, no? No. 35G, no? Which is that? 35G. Of,
35G, my lord. 35H, my lord.
H of the Central Excise Act 1944, within bracket the Act, is directed against the order dated 28th September 2000, passed by the Customs, Excise and Gold Control Appellate Tribunal, East Zonal Bench, Kolkata, within bracket Tribunal. The appeal was admitted on The tribunal referred the matter to this
May I
court.
take your lordship's kind leave?
Yes. Referred this matter, referred the matter to this court to decide the question within inverted comma, whether the Hon'ble Tribunal was justified in allowing the appeal without ascertaining the factual position of actual utilization of input appropriate to be charged to the electric induction furnace, inverted comma. We have heard Mr. Vipul
My lord, the
Kundalia.
question of law is, my lord has got the question.
We have heard Mr. Vipul Kundalia, learned senior standing counsel, assisted by Mr. Tapan Banja, learned
Aishwarya Raj.
Aishwarya Rajshri, learned standing counsel for the respondent, appellant department, and Mr. Arjit Chaudhary. Mr. Arjit Chakraborty, learned advocate appearing for the respondent assistant. The tribunal, in our opinion, has examined the factual position in a detailed manner and moved on to consider as to whether the demand was barred by limitation. Full stop. The show cause notice alleging wrongful availment of mod-VAT credit was issued for the period issued on 3rd April to 1995 for the period from 1/3/1990 to 31/3/1994 on the ground that the mod-VAT credit was availed in an improper manner. The appellant contended that the credit was availed after filing proper declaration and after producing materials before the department, which was received by the department in RG 23 capital A part 1, as well as in part 2. That apart, the RT, R capital T capital -12, numerical 12, returns were regularly filed by the assessee along with the duty paying, along with documents to establish that duty was paid, and on the said basis, credit was availed by them. Further, the assessee contended that the documents which are produced by them were defaced by the Central Excise authorities, and no objection whatsoever was raised by the range superintendent with regard to the veracity of those documents. The RT12 returns were thus finally assessed. That apart, the assessee contended that the Central Excise officers visited the assessee's factory regularly and examined their statutory records, as well as, please take a seat, as well as the materials received by them, as also the final products manufactured. And nothing contrary was pointed out by the team of officers who visited the assessee's factory. Furthermore, the assessee placed on record that the annual stock taking verification has also been done in the presence of the central excise officers, wherein the stock of the re-melting stocks and also other inputs lying in the factory were verified, and no objection was raised by the officers. Therefore, the assessee would contend that the revenue was not justified in issuing the demand beyond the period of limitation. Beyond the period of limitation, and in the absence of any suppression, the extended period of limitation could not have been invoked by the revenue. One second. The the tribunal examined the tribunal, after noting the facts, examined as to the correctness of the stand taken by the assessee before it. And it was pointed out that in the impugned order, in the order passed by the Commission of Central Excise, Calcutta 1, it has been observed that the defacing of documents does not mean that the concerned officer has verified the documents. And the main purpose of defacing is to prevent the same document for being used again for availment of mode VAT credit. Thereafter, the tribunal examined the purpose for which defacing of documents is done, and pointed out that it is not an empty formality to be done by the central excise officers having jurisdiction over the assessee. More particularly, at the time of defacement, the genuineness of the duty-paying documents is examined by the authorities, and it is only thereafter the document is defaced. The revenue did not dispute the fact that the assessee had produced the documents for defacement purposes, and there was no allegation that the assessee suppressed material from the revenue or made any misstatement of facts. Furthermore, the tribunal noted that that it is not in dispute that the RP12 returns were finally approved by the authorities. The importance of a final assessment of RT12 returns was considered by the tribunal, and it was held that the final assessment has been done after verifying all the particulars as well as the returns and the duty paid documents which were attached to the returns, and only after a thorough examination defacement has taken place. The tribunal, while considering as to under what circumstances the extended period of limitation could be invoked, rightly took note of the legal position that the department should establish that the assessee has availed credit by willfully misstating certain facts or suppressed material facts. And these acts are required to be deliberate acts with an intent to withhold information from the department. After noting the legal requirement, the tribunal examined the factual position and pointed out that there is no allegation of misstatement or suppression made by the department at any stage of the proceedings. More particularly when all the documents were produced by the SSC, examined by the revenue, and thereafter the final assessment was made. Therefore, the tribunal held that the extended period of limitation could not have been invoked by the revenue, and that the entire demand is barred by limitation. The tribunal was of the opinion that tribunal, while referring the matter to this court, referred the question as to whether the tribunal was justified in allowing the appeal without ascertaining the factual position of actual utilization. Limitation, the question of limitation is a legal issue which is required to be decided taking note of the relevant facts. If on facts the tribunal had come to the conclusion that the demand was barred by limitation, nothing prevents the tribunal from granting relief to the SSC on the said ground. And there will be no occasion to examine the merits of the matter, as such an exercise will be a sheer academic exercise. Thus, we are of the view that the tribunal rightly took note of the facts and took note of the undisputed facts and held that the extended period of limitation could not be invoked. For the above reasons, we find no grounds to interfere with the order passed by the tribunal. Accordingly, the appeal is dismissed and the question referred for consideration is answered against the revenue. Thank you.
Item number 27 of monthly list.
Bengal Hammer Industries.
No, this is my appeal.
Copy.
I am,
My lord, have they filed the paper book? They have not served me a copy.
yes, we have served, my lord. Everything has been served in due time.
Everything served.
Served.
Everything is done. On the department I have served. Now, this is a case of fixation of annual capacity.
Oh, annual capacity.
The earlier the hot
Whether the
period,
tribunal below substantially erred in law, dismissing the appeal without appreciating that refixation of annual capacity of
2009 was
production
served.
made by the commissioner on reviewing his own order without issuing show cause notice, without opportunity of hearing. Contrary to the principles of natural justice.
my lord, if your lordship takes
There
up
was
the
an interim
tribunal-
order passed by this honorable court wherein the direction was given to them to deposit the amount before the Registrar General. Whether they have deposited, I also don't know, my lord, whether they have deposited this amount or not.
Well, this is the original receipt of the deposition
Which টাকা দিয়েছে?
of rupees 7,50,000. Along with the order of the Honorable Division Bench.
Now, your contention was originally the ACP was fixed, annual production.
In 1998,
That
initially 1990,
1990.
revised in 1998 by the commission.
Oh.
Now in 1999, suddenly the Joint Commissioner came up with a fresh proposal of revision. I have no problem with that. The law was that 70% of the total annual capacity will be considered to be non-alloy, and the 30% will be alloy steel. And on 30%, the duty has to be paid at ad valorem basis or the actual production, whichever is higher. So even if I go down to 30%, I have to pay for the 30%. The commissioner in the year 1998 has allowed that. Now in 1999, the Joint Commissioner suddenly changed it, considering that 100%. Now I placed this before the Honorable Tribunal. The Tribunal said, kindly see the Tribunal order.
We saw the order.
The Tribunal said that it was done by 70%. He is looking into the 1998 done by the Commissioner.
1998, you are not agreeing.
Not, I am not agreeing. He is saying I have not challenged that.
Let us see the Joint Commissioner's order where he refixed the
Yes.
ACP. No, normally before refixation, they will conduct an inspection
Exactly,
and
19.
then a show cause notice will be
Yes,
issued.
Yes.
here, done here, my lord. Sokoj is at page 58, my lord. So that may be not telling with that is my stay application. Paper বিকে কত শোকজ
Show cause notice is not there. Copy of the tribunal.
Page 69 is a notice to show cause come demand in the paper book.
This is issued by the commissioner,
This is issued by the commission,
joint commissioner,
joint commission.
joint commissioner technical.
Yes.
No, that is issued by commissioner. Shokos has been issued by the commissioner, my lord.
Now, what is your reply to this?
Now, my lord, this show cause notice was on the basis of
Hmm.
this show cause notice. My lord will kindly see what is my grievance.
Hmm.
This show cause notice is on the basis of the 1999 refixation made by the joint commission. This is not a show cause notice proposing refixation.
Please show that relevant paragraph.
Yes, kindly come to the
In fact, 68, if you see, read 68.
68 is the 1999 joint commissioners report, refixation.
The Commission of Central Excise, after careful consideration, so and so, introduced so and so. Report given by the verifying officer, signed your authorized representative. Year 97, determined the annual capacity as so and so metric tons. Fixed duty liability for the 99-2000 at rupees so and so. To be paid amount of monthly liability. Deficit amount will cover all payments delayed beyond so and so.
Now, this was the question. This was under question. That how it has been made in 1999 without issuing any show cause notice, without it giving me any opportunity of hearing. Now, on the basis of this, my lord will find the next page, the show cause notice issued that as per this calculation, fixation of annual capacity, I have not discharged the duty. For the period from, kindly see.
So what the tribunal says is, you have not challenged this order.
Yes.
Yes. That is what tribunal.
But if this is the basis, when he goes before the tribunal, can he not question the correctness of this order? Because on the ground that he did not have an opportunity.
My lord, the question is the learned tribunal has rightly said, my lord.
Because if you know,
My lord, your lordship will kindly see the learned tribunal against the redetermination of the annual capacity of production. They have not challenged.
no. See, what happens is this redetermination was done on what date it was done, it's not clear.
My lord, that is
3/8/1999 is the letter issued to me.
That is correct.
Yes.
But in the body of the letter,
Nothing said.
the date on which commissioner has refixed is not
Nothing.
set. Number one. Secondly, the refixation has been done by the going through the particulars declared by the SSC.
Yes.
Then he fixes in accordance with the annual capacity determination rules, saying that this will be your annual capacity so and so metric tons. Based on it, immediately the joint commissioner issued show cause notice.
Yes.
This is actually, this order is communicated by the joint commissioner. The original order fixing the capacity by the commissioner is not here. Then,
Well, will kindly see page 67 for once. Because 67 was 1998. Kindly see 67. Talks about the details by the commissioner. First paragraph. Application such and such in terms of and this office earlier fixation order of event number such and such and such of April 98, 3rd April and 27th April. The commission has been pleased to kindly see the total capacity was fixed at such and such total capacity of 20,326.919 metric ton. As per formula and fixed monthly duty liability of 3,55,000, annual duty liability 2,68,000. for the period from April 98 to March 99. Kindly mark. Along with interest at the rate of 18% per annum on the deficit amount. The deficient amount will cover all the payment. Remaining 30% of the annual capacity of production, that is 6098.076 metric ton alloy steel as declared by you, or the actual production of alloy steel, whichever is higher, is to be cleared after discharging certain due to liability under section 3.
Now, there is no difference between the order in 98 and 99. You see the
It is there. It
No.
is there.
20,000.
The 70% and 30% calculation is not there in 99. Kindly see. That is where I am stuck up. He is asking in 1999 on the 100%. That is the illegality in this order of 1999. And on that basis, this show cause notice demanding the duty. So I said I am guided by 1998, which is issued by the commissioner after granting me 70%. And that was valid up to March 1999. Kindly see page 67. That was never been withdrawn. Now kindly see, Melody, page number 68, that is 1999 order, was made for the year 1999-2000. At the middle, the show cause notice was for 97-98, earlier period. So I said for the earlier period, I am covered by the earlier order, earlier determination.
Oh, this is for September 97 to March 98
Yes,
and April 98 to March 99.
correct.
So it is not for
Covered by
April.
1999. It is covered by 98, the fixation.
So this is not the, this one you had.
Then what is his grievance, my lord? Then what is his grievance?
My grievance was that on the basis of 1999 fixation.
What was impugned before the tribunal?
Yes.
You show
My lord,
that. impugned.
Yes, yes, showing.
My lord, that is the order of the appellate authority.
No,
Yes,
this
yes,
was
yes.
the order of the adjudicating authority, which
Yes.
starts from page 87.
Yes. No, this is also for the period September.
Yes,
For that show cause,
Yes.
yes.
for that show cause. Now, what calculation he has taken into consideration, kindly see. Kindly come to page 90.
1 second.
Last paragraph. This is the finding. But the calculation has been made on the basis of the communication on 14/6/1999,
Right.
which is at page 66. The
14.
same thing without granting 70%, 30%. Page 66. Number 17550G, dated 14/6/1999.
So this refixation, you
Yes.
did not have notice.
Yes. Now the tribunal says that since you have not challenged this 14/6/1999 refixation by Joint Commissioner, you cannot challenge this order.
You see, please come to their grounds. Or before that, in their statement of facts, page 97. Paratin. Appellant received a show cause notice cum demand dated 28/5/2001, issued by the Commissioner of Central Excise. By the said order, it was alleged that they are required to pay duty as per the capacity determined by the Commissioner on the entire determined quantity and not on 70% of the determined capacity. Appellant was asked to show cause, etc. Then you come to page 99. Ground number 2.
That is the only group.
Joint Commissioner failed to appreciate. Appellant filed application before the Commissioner for allowing them to pay Central Excise duty on 70% of the non-alloyed steel manufactured by them through their rolling mill. 30% of the products were to be cleared by under Section 3. The order of the Commissioner was clear and unambiguous. Appellant acted on the order. No appeal has been filed with the department against said order. Order has reached its finality, cannot be challenged subsequently. When the department considered the order of the learned Commissioner was not proper and valid, they should have filed an appeal. Then they are referred to some decisions of the tribunal. Therefore, the Joint Commissioner, when he issued notice stating that he will demand duty on the entire quantity and not on 70%, the assessee could not be blamed because he was following the earlier order, 70/30, and he was paying. That is why they have referred to various decisions of the tribunal, where the tribunal held that
There cannot be review of the annual capacity by himself.
and
without
it cannot be
preferring
stated that there was they have not paid duty at the appropriate capacity. So that was the grounds. So the tribunal cannot say you did not challenge it. He did not have an opportunity. In fact, the subordinate authority initiated action.
My lord, on what basis? Because the board has given instruction. That's why the subordinate authority.
No,
has
no,
done
no,
this.
my learned friend is mistaking that
My lord, your lordship
instruction-
kindly see the order in origin.
instruction of the board was in general for revising the annual capacity of all hot rolling mills. But that has to be done in a manner which is prescribed under
The
the law.
board will give instructions, circulars. when it has to be applied to the assessee, there is a procedure. He accepted the department accepted the order passed by the commissioner, 70-30.
Yes.
He had been remitting duty based on that. Now the joint commissioner says, no. There is some redetermination. I will charge on the entire amount.
No, that is after the board's instruction, my lord.
It
That
can't
is
be.
after the board's instruction. Your lordship kindly see the adjudication order.
This is the adjudication order.
Yes.
Page number 106.
Yes.
No,
my
the
lord.
order in appeal.
Order in appeal. Yes, my lord.
No. 106 is order in appeal.
My lord, that may be paragraph 6
Of?
appellate authorities order.
Okay. Well, this is-
Para 7.
Para 7.
109.
I find the crux of the appellant's contention is that they had discharged their duty liability on the impugned goods in respect of the material period as per orders dated 3/4/1988 and 13/8/1988 of the jurisdiction pertaining to determination of the annual capacity of production of the said orders, not being challenged by the department, achieved finality, and the impugned demand arising out of the subsequent order issued by the joint commissioner, who is subordinate to the commissioner, redetermining ACP in respect of the same period is not sustainable. In this context, I find that the relevant letters dated 14/6/1999, 3/8/1999, the joint commissioner had simply communicated the decision of the jurisdictional commissioner, reviewing and superseding the earlier determination of ACP
That cannot
that
be. That is the
material
question.
period weeks before the white board's letter dated such and such.
Well, the board will issue instructions.
Yes.
Yes, in these sort of industries, you should refix the ACP. But there is an order already, binding order of the commissioner, which is accepted by the department, followed by the SSC. So you apply the board circular, then you review the decision. He has not issued any notice. Page 67, once again, there is no date for this order.
Yes, date is at the top, my lord, 13/8/1990.
No, this is by the additional commissioner.
Yes, this is communication.
No
No date of
commissioner date is not there.
No date.
And over the page, here 67, 70-30 is very clear.
66. 66 is relevant in this case.
14/6.
14/6/1999, what they are relying, and what we are relying is page 65, 3/4/1998.
3/4/98,
Issued by commissioner. Kindly see.
commissioner,
Yes.
which was reiterated in page 67.
67 reiterated. Exactly. 38.
So his case is very, very simple, Mr. Maiti. This order 3/4/98 order of the commissioner remains valid. Board has of course directed to do something.
Yes.
You review this order, issue him a show cause notice. That has not been done. Instead, what he did was, he issued show cause notice
My lord.
based on page number
66.
yes. Page 66. Fixation of ACP.
My lord, your lordship kindly mark one thing, my lord.
Kindly
The-
see page 66,
commissioner-
last line, date and number is also left blank. Maybe this, sorry, my lord, maybe this is in the type copy. Original copy might be having. তোমাকে কাছে 14/6 এই যে 14/6 এর original letter.
Now what to do after all these?
My lord, your lordship kindly mark the commissioner's letter is 3/4/1998.
Yes.
Correct.
And the board's instruction is 13/11/1998. That is after that
Board instruction.
board's
was for
instruction
delivery.
that is
13/11/98.
13/11/98. So therefore 14/6/1999 letter has been issued.
So what he says is, I need an opportunity there.
Exactly.
And if you are going to do it for the back period and hold him guilty of not paying the correct rate of duty, you will demand interest, you will do a levy penalty.
And
So,
that too without any
That- in
verification.
that event, my lord, they cannot say that the joint
Let us
commissioner.
see, no, let us see the board circular.
Yes, board circular is there. Next page.
He was a-
মনে হচ্ছে নেই। Most probably it has not been annexed, my lord, 13/11/1998.
And they have relied on some decision of the tribunal.
November 1998.
13 November 1990.
What is the name of the company?
That is Bengal Hammer.
This is page 118 is an order of the tribunal
Yes.
in respect of Hon'ble Ispat. Present two appeals are filed by the revenue against the order of Commissioner set aside the order original by observing that the jurisdictional commission of Central Excise letter dated 25/3 has permitted the SC to work under the provisions of section 3. As such, he observed the availment of moderated was lawful. Revenue in the contented said letter of commissioner allowing the SC to work under procedure instead of paying duty under 3A was not in accordance with the clarification issued by the board wide circular dated 19/11/98. However, the junior department fairly admits the commissioner's permission was neither withdrawn nor challenged
Yes.
before the higher forum. In as much as the commissioner's order dated 25/3/99, in the assessee's case 3/4/98, allowed the revenue to work under the provisions of section 3. The respondents had not discharged the duty burden under the said provisions after avail. Find no infirmity in the order. Typed copy is at page 120. Then Hon'ble Ispat, another order,
123.
123.
Type copy, my lord, at. No, this is not, no type copy.
Page 125, para 5 is the contention. So Bagaria so and so. Acted in accordance with the order dated 25/3/99.
Which was never challenged.
Yes, the order was not appealed against so and so. Page 130, I think there is another order. Dealing with powers of the collector commissioner review. Do not have power to review their orders. It was especially so, even Sestat did not have such a power. Para 4.
And that is passed by the tribunal and the similar member, Archana Vada. All Archana Vada.
So how does?
All Archana Vada.
We are also sitting same.
Yes, the same judge.
Maybe, but
What my landlord wants to see.
My lord,
Indicate, I don't understand.
I indicate that, my lord,
What
separate order, separate tribunal. One has been decided, that's why they are relying. Several decisions they are relying.
You are also.
You are also the same tribunal.
Covered by decision, covered by. Decision.
And let me check whether this has been.
Probably my landlord friend is not getting any other point to argue.
No. I have many points to argue there.
But not arguing.
But then.
Yes, my lord.
You can't expand the scope because tribunal did not go into that aspect at all. He had no occasion to challenge the refixation because refixation order was done based on a board circular in November 1999.
Yes.
Based on that, the Joint Commissioner said, this is the refixation issue for process.
Yes.
His contention itself is, I have followed the fixation dated 3rd April 98. Unless this order is reviewed after opportunity, you cannot demand duty on the entire quantity. Because the 70-30% cannot be altered. Assuming during the concerned financial year or during the year in question, if the assessee wants to opt out, he can't opt out. We put it other way.
Yes, madam.
Suppose he says, no. He has already been fixed at 100, 100%. He then says, no, I've altered my production, machinery, etc. Now you have to do it at 70-30. The 30% will be duty liability under section 3. He can't do that. In that year, he can't do.
Yes.
Once the annual capacity is fixed, it is binding on him.
Unless I appeal.
Yes. If it's binding on, it's equally binding on the department. So you could have, the commissioner could have issued notice saying that, see, look here, board has directed me to redetermine. This is how I propose to redetermine. Even if he redetermines, he cannot encroach upon the period covered
From
by the
1990.
3rd April 98 order. So there are only two ways. One is allow his appeal in its entirety or send it back to the tribunal to examine this issue.
Well, I have no issue. I have no problem.
Remand the matter to the tribunal to re-examine that issue, my lord.
Because it is not a question of not challenged. He could not have challenged. Because the commissioner has not put him on notice. He followed because commissioner was more concerned about
No, 14/6/1990 letter was very much aware to them. So 14/6/1999 letter, when they came to know this, then why they have not challenged at that point of time? Now they are saying that 14/6/99 and my show cause notice is for the earlier period, my lord. Your lordship will kindly
all
consider.
right. Now, on identical issue,
Yes.
matters have attained finality. That has been followed by the tribunal. That is his case. In his appeal grounds, he has referred to that. Now, can you selectively appeal against this assessee alone? If that has attained finality. By taking a different stand in this matter. In fact,
And see the letter of the P490.
you come to this decision, Mighty, that Indian Oil Corporation was the Commissioner of Central State of Baroda, page 136,
136.
at page 138.
Yes.
Shri So-and-so Learned Additional Solicitor General has fairly conceded that as against the order passed by the tribunal in the case of Hindustan Petroleum, no appeal was preferred by the department. Order has attained finality.
Same judge.
Since no appeal has been preferred, the same has become. The department is not entitled to raise the same point in other cases in view of the decision of the court in so-and-so, all Supreme Court decision. And the extracted portion, Birla Corporation. And it, Supreme Court says,
Wherein it has been held that if no appeal is filed against an earlier order or the earlier appeal involving the identical issue was not pressed by the revenue is not entitled to press the other appeals involving the same question.
the facts are identical. In fact, those two decisions, the Hooghly Ispat is identical. And one more decision they have enclosed. Commission of Central Excise Mumbai versus Begin Industries, 197 ELT. Paragraph 10, page 143. Middle. This apart, the earlier or decision of tribunal between the parties, same facts so on. So revenue did not file appeal. Revenue is precluded from taking a different stand in the present appeal. Tata Engineering Locomotives, Burger Paints, Birla Corporation. One more decision is Jindal Dye Intermediary.
Yes, page 144.
Since the revenue is precluded from taking a different stand,
But this is
we'll allow the appeals.
Page 149, para 17.
The tribunal didn't even go into that aspect.
No.
Please come. This appeal filed by the SSC under section 35 capital G of the Central Excise Act 1944, within bracket the Act, is directed against order dated 25th June 2008, passed by the Customs, Excise and Service Tax Appellate Tribunal, East Zonal Bench, Kolkata, within bracket Tribunal. The appeal was admitted on 8th April 2009 on the following substantial question of law. Page 153 and 154, only one question. We have heard Mr. Arjit Chakraborty, learned counsel appearing for the appellant SSC, and Mr. K.K. Meti, learned senior standing counsel, assisted by Mr. Tapan Banjal and standing counsel for the respondent department. The short issue which falls for consideration is whether the proceedings initiated by the Joint Commissioner Technical, pursuant to his order dated 3rd August 1999, by issuing a notice to show cause cum demand, demanding Central Excise duty on the ground that the annual production capacity of the appellant had been refixed pursuant to a circular issued by the board dated 30, what is the date of that circular?
13th 11/1998.
Where, just
My lord, that is in the order of that appellate authority. Your lords will appellate authority order paper book. '95. My lord, internal page 5, that is of that appellate authority's order. Board's letter dated 13/11/99. Board
13/11/1990. The question would be whether the order passed by the Commission of Central Excise, Calcutta 2, dated 3/4/1998, which was holding the field and accepted by the department, could have been unilaterally revised by a subordinate authority, namely the Joint Commissioner, solely due to a circular issued by the board. It is not in dispute that the Commission of Central Excise had fixed the annual capacity of the SSC under the hot re-rolling steel mills annual capacity determination rules, 1997, by order dated 3/4/1998. By the said order, the Commissioner, after examining the submissions made by the SSC and also after considering the particulars declared by the SSC under the rules and the notification dated 30/8/1997, and after re-verification based on a request made by the SSC and taking into consideration the report given by the Assistant Commissioner of Central Excise within Howrah within bracket North Division, redetermined the annual capacity of the appellant, SSC, as 20326.919 MT metric tons and 14228 MT within bracket 70% non-alloy steel, bracket close, and fix the duty liability for the year 1997-98. The said order further stated that the remaining 30% of the annual capacity of production, that is 6098.076 MT alloy steel as declared by the SSC, or the actual production of alloy steel, whichever is higher, is to be cleared after discharging the central excise duty liability under section 3 of the Central Excise Act 1944. After the circular was, after the instruction given by the board, the Commission of Central Excise appears to have unilaterally redetermined the annual capacity, production capacity of the appellant, and admittedly no opportunity was granted to the appellant SSC to place materials, as no show cause notice was issued by the commissioner proposing to redetermine the annual capacity purportedly to be based upon the instruction given by the board. This unilateral decision taken by the commissioner by determining the annual capacity on the entire quantity, that is 100%. The Joint Commissioner had redetermined the duty liability and issued show cause notice. Though the appellant had submitted the reply to the show cause notice, on 30th July 2004, stating that they have been manufacturing both alloy and non-alloy steel products, and their alloy steel products were approximately 30% and non-alloy steel products was 70%. They had approached the Commission of Central Excise stating that they would be manufacturing 70% of non-alloy steel and 30% of the alloy steel of annual capacity of production, which was declared by them by letter dated 9/9/1997. And they would be paying central excise duty or non-alloy steel as per determined capacity on pro rata basis. And for alloy steel, they would be paying duty at 15% ad valorem after observing the central excise formalities. Based on the request letter given by the SSC dated 9/9/97, the Commission of Central Excise, by order dated 16/10/1997, refixed the duty liability. By further letter dated 27/3/98 of the SSC, they requested the Commissioner to fix the duty liability at 70% of the total capacity of production for non-alloy steel products, and 30% would be paid by them under the provisions of Section 3 of the Act. The Commissioner examined the matter and by order dated 3/4/98 determined the annual capacity of their unit at 2326.919 metric tons and 14,228 MT metric tons, within bracket 70% of non-alloy steel, and accordingly fix the duty liability. Full stop. Regarding 30% of the alloy steel products, it was ordered that the same was to be cleared from the factory under the provisions of Section 3 of the Act. Subsequently, a corrigendum was also issued on 22/9/1998. Based on the said order, the Joint Commissioner of Central Excise also determined the duty liability. Thereafter, the show cause notice cum demand was issued on 28/5/2001, stating that the SSC was required to pay duty as per their capacity determined by the Commissioner on the entire determined quantity and not on 70% of the determined capacity. The assessee therefore contended that when no appeal has been preferred against the original order of the commissioner determining the annual capacity at 70%, refixation could not be done and at 100%. This contention was not accepted by the adjudicating authority, who passed an order on 10th August 2004 affirming the demand proposed in the show cause notice. Aggrieved by the same, the assessee preferred appeal. Before the commissioner, within bracket appeals to, Central Excise, Kolkata, reiterating the stand taken by them in the reply to the show cause notice. The commissioner, by order dated 11th February 11/2/2005, dismissed the appeal solely on the ground that the jurisdiction commissioner had reviewed the earlier determination and superseded the same by determining the annual capacity production of the assessee for the material period in the light of the board's letter dated 13/11/1998. However, the issue agitated by the assessee was not considered by the appellate authority. Agreed by the order passed by the appellate authority, the assessee preferred appeal before the tribunal. The tribunal non-suited the assessee solely on the ground that the assessee did not challenge the order passed by the commissioner redetermining the annual production capacity. On perusal of the grounds of appeal filed by the tribunal, before the tribunal, by the assessee, we find that the specific contention raised by the assessee was that the earlier order passed by the commissioner having attained finality, accepted by the department, not appealed against, review of the order could not have been done unilaterally by a junior officer, by an officer who is junior in rank than the commissioner. This contention raised by the assessee was not considered by the tribunal. Interestingly, identical issue has arisen in respect of the other assessees who are also carrying on similar production activities. And one such case traveled up to the tribunal in the case of Hon'ble Ispat Limited, and in appeal number E, capital E -718 to 719 of 2001, within bracket Commission of Central Excise, Kolkata, Roman 4 versus Hon'ble Ispat Limited, the tribunal, by judgment dated 22/1/2002, dismissed the appeal filed by the department and affirmed the order passed by the Commission of Central Excise Appeals, which granted relief in favor of the said assessee. The learned tribunal pointed out that the availment of modvat credit by the said assessee was lawful. The contention of the department, which is similar to the submissions made by the learned senior standing counsel before us,
and to that extent, my lord, 14/6/1999 letter has been issued with the taking the concurrence of the commissioner. That is, my lord, kindly, that is the commissioner of Central Excise. That is the middle portion, my lord.
The contention raised before us, stating that the order of the commissioner originally fixing the annual production capacity was not in accordance with the clarification issued by the board dated 19/11/1998. The tribunal pointed out that the order passed by the commissioner was neither withdrawn nor challenged by the department before the higher forum, and therefore held that the said assessee had rightly discharged the duty burden. Similar issue also arose before the tribunal in the case of Hon'ble Ispat Limited versus Commission of Central Excise, Kolkata Roman 4, in appeal number capital E 813/2002, and by order dated 18/2/2003, the learned tribunal had allowed the appeal, accepting the stand taken by the assessee that they had discharged the duty burden based on the determination of the annual capacity by the commissioner, and the said order having not been challenged before a higher forum, unilaterally the annual capacity cannot be refixed.
But page 123 is the final order.
The tribunal in the said decision also noted the other decisions of the tribunal on the similar point.
Page 127 is relevant towards bottom.
Correct. The tribunal did not go into these aspects, though the same was specifically canvassed by the assessee in their appeal before the tribunal. The question thus would be whether the department can be permitted to take a different stand when they have not preferred any appeal against those decisions of the tribunal which were decided in favor of those assessees on an identical issue. In this regard, it will be beneficial to refer to the decision of the Honorable Supreme Court in Birla Corporation. In Birla Corporation Limited was a CCE 2005-69 RLT 580 within bracket SC. The Honorable Supreme Court held that when a same question arises for consideration on identical facts, the revenue cannot be permitted to take a different stand. And in the said case, the appeal, and it was pointed out that the earlier appeal involving identical issue was not pressed and dismissed. And the revenue having taken a conscious decision to accept the principles laid down in the said order cannot be permitted to take opposite stand in a different matter. And if the same is permitted, the law will be in a state of confusion and will place the authorities as well as the assessee in a quandary. QUANDARY. The said decision of Birla Corporation as well as other decisions on the point were relied on by the Honorable Supreme Court in the case of Indian Oil Corporation Limited versus CCE Baroda 2006-76 RLT 548 within bracket SC. And in the case of Commission of Central Excise Mumbai versus BIGEN Industries Limited 2006-197 ELT 305 within bracket SC. And Jindal Dye Intermediate page 142 intermediate Limited versus Commission of Customs Mumbai 2006 197 ELT 471. Oh, Commissioner, sorry. Collector of Customs Mumbai 2006 197 ELT 471. All the law laid down in the above decisions is clear that once the department has accepted the orders passed in identical issues, considering the scope of the revision of the annual production capacity of those units who are also carrying on similar production activities, the department is precluded from taking a different stand in other cases, more particularly in the case of the SSC. Thus, we find that the SSC has made out sufficient grounds for us to interfere with the order passed by the learned tribunal. For the above reasons, the appeal filed by the SSC is allowed and the order passed by the learned tribunal is set aside, and consequently the orders passed by the first appellate authority and the Joint Commission of Central Excise are set aside and the demand is quashed. The substantial question of law framed for consideration is answered in favor of the SSC.
Item number 28.
My lord, I am appearing for the appellant.
Yes, where are the questions, madam?
My lord, kindly fix the matter in the monthly list of July.
Why? No, you argued today, please.
My lord, this matter was allotted to us after filing. Whether service has been done or not is not clear to us.
Doesn't matter. You make out a case for interference, then we will see. Anjan, where is the admission order? Kamalakshi Finance. Where is it? Krishna Flowers. Oh, yes. $41. In fact, the tribunal has recorded,
Yes, my
it has
lord.
followed the earlier orders.
Yeah.
In page 145, para 5, both sides agree.
My lord, I don't have the.
All
book
right,
now.
please hear us.
Yeah.
Both sides agree that the present case is similar to the earlier cases decided by the tribunal and referred to by the adjudicating commissioner in the impugned order, as well as in the cases decided by us in associated polymer. As we take the same view, we have taken in the case of associate. The department was aware of the contrary orders of the tribunal. It took no steps to file appeal against the same in the appropriate higher judicial forum. Adjudicating Commissioner in this case has committed no wrong in following the earlier decisions of the tribunal in similar cases. In fact, as recorded by him, he was duty bound to do so in view of the Honorable Supreme Court's decision in Kamalakshi Finance, which we have quoted above. We fail to understand as why the board, after noting the reasons given by the adjudicating commissioner, after noting the observation of the Honorable Supreme Court in Kamalakshi Finance, had chosen to direct the authorities to file this appeal. It is rather inexplicable as to why the board did not appeal against the earlier orders, passed in so and so, and accepted the same. The adjudicating commissioner has therefore correctly followed the tribunal's earlier order, which have not been appealed against by the department, and he has also acted correctly in terms of the decision of the Supreme Court. It sends a wrong signal to the commissioners and field officers working in the board that their orders can be called in question even when they follow the orders of the tribunal. Therefore, dismissed. Nothing is there.
My lord, in this regard, my instruction was
Nothing is there. Please come. This appeal filed by the revenue under section 35 capital G of the Central Excise Act 1944 within bracket the Act is directed against the order passed by the order dated 12th August 2008, passed by the Customs, Excise and Service Tax Appellate Tribunal Eastern Zonal Bench, Kolkata, in appeal number EDM 266-267/2005. No, sorry. In, strike out that appeal number. In, correct, sir, correct. EDM 26. The appeal was admitted. What happened? Admitted on June 10th, 2009 on the following substantial question of law. We have heard so and so learned standing counsel for the appellant board. The short issue which falls for consideration is whether the order passed by the learned tribunal dismissing the appeal filed by the revenue and affirming the order passed by the adjudicating authority dated 29/3/2004 calls for interference. The learned tribunal has noted that the adjudicating authority, namely the commissioner, had taken note of the earlier decisions passed by the tribunal on identical cases, or rather group cases, which were all which all arose out of the allegations which were made against those assessees, as well as the respondent assessee by the Directorate General of Anti-Evasion. The orders passed by the tribunal had attained finality. Therefore, the issue would be whether the adjudicating commissioner could have taken a different view. Had the adjudication commissioner taken a different view, it would have been held to be against judicial discipline. In this regard, the learned tribunal rightly noted the decision of the Honorable Supreme Court in Union of India versus Kamalakshi, KAMLAKSHI, Kamalakshi Finance Corporation, 1991, within bracket 55, ELT 433 within bracket SC, wherein it was held that principles of judicial discipline require that the orders of the higher appellate authorities should be followed unreservedly by the subordinate authority. The orders passed by the tribunal in the case of Associated Polymer Industries versus CCE, Kolkata 2, 2008 227 ELT 449 within bracket TRI hyphen Kolkata bracket close, was in the case of a decision in a group case similar to that of the assessee's case, which was considered by the tribunal and the appeal filed by the revenue was dismissed. I'm sorry, the appeal filed by the assessee was allowed. The said order was accepted by the department and no appeal was preferred. In such circumstances, we are of the view that the learned tribunal was fully justified in following the earlier decision and dismissing the appeal filed by the revenue. As pointed out earlier, if the adjudicating commissioner did not follow the earlier order passed by the tribunal, then he would have been put to serious problem. Therefore, the order passed by the learned tribunal, affirming the order passed by the adjudicating commissioner, is just and proper and does not call for any interference. Accordingly, the appeal is dismissed and the substantial question of law is answered against the revenue. Next.
Item number 29.
Lord, in this matter, I am appearing for the appellant. The issue before your lordship is very short, my lord. Whether before issuance of show cause notice, they have paid the service tax and interest. Then
at that time, that decision said, if you had done it, that thereafter, Supreme Court said after that Dharmendra Textiles,
yes,
they said whether you pay before or after, it will not make a difference. You are liable.
Liable to pay the penalty has, my lord. The penalty has been waived by the tribunal, my lord, under section 76 and 78 of the Finance Act. Yes. My lord, your lordship will kindly find the order of the tribunal at page 97 or page 97 of my paper book. Held. Tribunal has categorically held, my lord, but
9,67,000 low tax.
my lord, low tax, my lord, that is prior to that, my lord. It is on 2008.
Pending appeal.
Pending appeal, my lord. My lord, penalty.
No. This appeal, please take down. This appeal filed by the revenue under section 35 capital G of the Central Excise Act 1944 is directed against the order passed by the Customs, Excise and Service Tax Appellate Tribunal, East Zonal Bench, Kolkata. In S Tax Appeal number 119 of 2008, dated 1/10/2008. The appeal was, where is the question of appeal was admitted on 17th June 2009 on the following substantial question of law. Page number 121 and 122, only one question.
Well, the question of law may be left open, my lord.
Definitely. We have heard Mr. K.K. Meti, learned senior standing counsel for the revenue, appellant revenue. On perusal of the order passed by the learned tribunal, we find that the service tax demanded is rupees 9,67,681. If that be so, the case being that be so, the revenue cannot prosecute this appeal, and the appeal has to be dismissed on the ground of low tax effect. The circulars issued by the board in this regard would fully apply to pending appeals before this court. Thus, by applying the said circular, this appeal is dismissed on the ground of low tax effect. Full stop. The substantial question of law framed for consideration is left open. Next.
Item number 30.
Lordship, Mr. Vipul Kundalia is appearing for the appellant Central Excise Authorities. He is on legs in court number 34. Lordship is requested. Lordship, I'm not briefed in this matter.
No, you should have, no. You should morning, or at least it's running in the list for quite long.
I'll keep this in mind, Lordship.
the mode of publication of appointment of central excise officers being procedural provision, whether a tribunal below substantially erred in holding customs authorities against the customs authority only because the appointments were not notified in the official gazette, although there has been wide circulation of the appointments through the website.
And I tell you, Lordship, my lord, there were 6 appeals which were heard together by the tribunal. In one case, the lead matter being Kothari products.
Which is the lead matter?
My lord, kindly take my lord. My lord, I am representing Berger Pence. If Lordship kindly takes the impugned judgment and order.
Page 238.
Yes. Lordship will find the lead matter was Kothari products.
Kothari products.
Now, my lord, Kothari products carried this judgment to its jurisdictional high court being Guwahati High Court. Now, my lord, Guwahati High Court has affirmed this judgment.
No, Kothari products succeeded in the matter.
Kothari products was one of the 6 appeals.
Yes.
By a common judgment and order, all the 6 appeals were disposed of.
Dismissed.
Dismissed in favor of the assessee.
Ah.
Now, Kothari, the Commissioner, the Union of India carried this. I'm so sorry. Carried this matter. I'm so sorry. Carried this matter to Guwahati High Court, and Guwahati High Court has decided the appeal against the revenue. And I have the judgment even rendered by the Guwahati High Court.
So, according to you, the posting orders should be notified in the gazette.
Yes.
And thereafter only they become.
Yes. If your lordship so pleases, my lord, may I just hand up to your lordship the judgment rendered by Guwahati High Court, affirming the judgment rendered by the tribunal. Eta din, lordship.
Oh, their argument must have been that it is only directory.
Yes.
If the board notifies it, that is sufficient. Gazette publication will.
Yes, but Rule 3 of read with Rule 2F of the Central Excise Rules. Rule 2F defines what is notification. Rule 2F says notification would mean notification published in the official gazette. And Rule 3 provides for the manner of appointment of the officers of the Central Excise Rules, if your lordship so takes.
And the tribunal has referred to some other decision.
The tribunal has referred to its own decision in the case of Nafar Chandra Jute Mills.
Nafar Chandra Jute Mills. That has attained.
Man, I'm not aware.
That we can easily verify. But in their grounds, have they said anything stating that against Nafar Chandra they preferred appeal?
Yes.
Where is your brief? This you don't have the paper book.
No.
You take the paper.
But my lord, I have checked up the judgment rendered by Guwahati High Court in Kothari. My lord, that has not been carried to Supreme Court.
They should
so
have
the
done.
revenue should have either carried the that judgment to the Supreme Court, or in that event, my revenue has accepted the judgment so rendered by Guwahati High Court.
Now, by virtue of this defect,
yes,
is it not a curable defect?
My lord, I believe, my lord, this
on
is
that particular date, if it is not notified,
right,
the authorization may be invalid.
Right.
It doesn't matter. He can reauthorize or the appropriate
if your
authority.
lordship kindly takes the ground, the question which was formulated by this Hon'ble High Court, as well as the pleadings, your lordship will find that this defect was perhaps not cured or subsequently cured.
Yes.
Subsequently cured, my lord, that the facts would reveal. But my lord, the question now arises is that when the review committee decided the matter, they were members of the review committee under section 35(1)(b), constituted under section 35(1)(b). And the decision was taken under, my lord, this section 35(e). So my lord, the review committee comprised of the commissioners who were not appointed in accordance with the manner so provided for in the statutory rules. That is the question.
All right. So the whatever order was passed by the review committee has not been gone into by the tribunal on merits.
No, no,
Huh?
certainly.
So therefore, a fresh exercise can always be done.
Well, perhaps my lord, the revenue should have carried the matter to Supreme Court.
No, they let them accept the mistake. If they accept the mistake and they
They
hold
accept
that
the mistake.
the decision, a fresh review committee with officers duly notified could have been constituted.
But this is a
If
2008 matter.
No, at that time.
At that time, they could have done so.
Without prejudice to carrying the matter to Supreme Court, they could have constituted a fresh review committee in accordance with 35.
Yes.
And then taken up the matter.
And my lord, the Guwahati High Court decided the matter long back in 2012.
Would you kindly give me a short?
No. You should read. See, when the brief is lying in your chambers, you should read. It's the best opportunity. He can come and join. Mr. Kondalia can come and join.
Well, your lordship would obviously recollect that in case of, in fact, this assessee in an income tax matter, that is Budget Pens 266 ITR 99, when the revenue is accepted.
Yes. Berger Paints, Birla Corporation.
That is there.
Hindustan Steel.
Hindustan Steel revenue has accepted the
Lordship, I'm
judgment.
extremely sorry for the inconvenience caused to the court, but please
No.
grant my request.
We are not
Lordship, give me a short
inconvenienced.
passover in this matter. I'm extremely sorry for the inconvenience caused.
It all depends on the construction of the rules, my lord. Namely, Rule 3 and Rule 2.
But after this decision,
yes,
has there been any amendment to the rule?
No. Subject to correction, no. Well, I've got 2015 Act. Kindly take my lord, Rule 3.
So Guwahati High Court held that in Rule 3(2), the word may has to be read as mandatory.
Yes.
That is the
Ratio laid down by Guwahati High Court. The lordship kindly takes the Central Excise Act.
Yes.
The lordship will find Rule 3 has to be read in conjunction with Rule 2F.
This is Act only.
Kindly take, man.
So rules will be there.
Rules will be there. Kindly take.
It is this Central Excise Manual, the big book, no?
Yes. But I believe no amendment has been made to the rules because this is 2015. Well, after 2017, there has not been any major amendment.
Which rule you are referring?
I am referring to Rule 3 and Rule 2F. Kindly take Rule 3 first. Rule 3(1). The board may by notification appoint such person as it thinks fit to be Central Excise Officer to exercise all or any of the powers conferred by or under the Act and these rules. Now, my lord, now kindly take, even for jurisdiction, my lord, the notification has to be issued. That is sub-rule 2.
That is there.
Kindly take the definition of notification which would appear at Rule 2F. Notification means the notification published in the official gazette. On a conjoint reading of Rule 3 and 2F, my lord, it is my most respectful submission before lordship, my lord, this rule cannot be construed to be directory. It is of mandatory nature. So the condition so laid down has to be complied stricto sensu. Well, there is another judgment rendered by well, the Supreme Court in Union of India versus Param Industries. This is 2016-16 SCC
Yes.
692.
Sir, it's coming.
I take copy. Yes. But kindly take paragraph 4 and 5.
That's what I took. It should have been. Page number 75, 77. And this was for during, what is the period involved?
And the
Prior
period,
to 14?
period involved. Period to what?
In fact, as pointed out, rightly pointed out by Lordship section, you please come to section 35,
Of-
capital B.
Yes, 1B. 1B.
The word may by notification in the official gazette has been substituted by the word may by order. But this substitution is the effect from 6/8/14.
Your Lordship is referring to 1B.
1B, 35B, 1B.
1B.
The Central Board of Excise and
Well,
Customs.
this is constitution of the committee.
Yes.
Well, I am today. But the
No, let
committee,
us see that notification, because wherever the word notification, the official gazette, whether it has been substituted right through the act.
may by order. Well, this amendment has been inserted. No, amendment has been inserted.
Yes, substitution took place with effect from 6/8/2014.
2014. Well, this is
Yours is prior, no
prior.
problem. That's why we asked you whether there has been any amendment. That's the base.
Yes, my lord.
That's how the legislature takes away the basis of the judgment.
Removing the basis, my lord, the judgments are rendered nugatory. But my lord, my submission would be, this is regarding constitution of the committee. My lord, the committee would comprise of the commissioners, the
Yes.
chief commissioners. My lord, I am on the appointment as chief commissioners or commissioners. Their initial appointment. So, my lord, the appointment as commissioners would not get cured by even by amendment made to section 35(1)(b). Because first they have to be appointed as commissioners or chief commissioners as the case may be, and then only a committee could be constituted comprising of such commissioners or chief commissioners. But again, my lord, this amendment, as my lord rightly framed from your lordships, my lord, this is prospective.
Now, this the committee consists of three chief commissioners.
Yes, my lord. Yes. Kindly take, my lord, along with this 35E. If your lordship kindly takes 35E.
So this is the power of review.
The power of review. Any. Committee of Chief Commissioners of Central Excise. My lord, I am on the appointment as Chief Commissioners. That was not notified in the official gazette, admittedly. My lord, so far as the constitution of the committee, it may be made by way of order, but subsequent to the amendment made in 2014. But there cannot be any cavil to that
But
proposition.
there are decisions which say
Yes.
that non-publication on in the gazette,
Yes,
official gazette, is a curable defect.
yes. But kindly take this Supreme Court judgment which I just handed up to your lordships. Kindly take from paragraph 4. May I just read it out for your lordship's kind consideration? What we find is that the High Court has stated that for bringing the notification into force and make it effective, two conditions are mandatory. One, the notification should be duly published in the official gazette, and it should be offered for sale on the date of its issue by Directorate of Publicity and Public Relations of the Board, New Delhi. In the present case, admittedly, the second condition was not satisfied in as much as it was offered for sale only on 6/8, as it was published on 3/8 in the late evening hours, and so and so. We are in agreement with the aforesaid view taken by the High Court, which is in conformity with the law laid down by this court in Harla versus Rajasthan State of Rajasthan, wherein this court formulated the aforesaid principle in the following manner. The principle underlying this question has been judicially considered in England. For example, on a somewhat lower plane, it was held in Johnson versus Sargent and Sons that an order of the food controller under the beans, peas, and pulse requisition order 1917 does not become operative unless it is made known to the public. And the difference between an order of that kind and an act of British Parliament is stressed. The difference is obvious. The acts of British Parliament are public enacted, debates are open to public, and the acts are passed by accredited representatives of the people who in theory can be trusted to see that their constituents know what has been done. They also receive wide publicity in papers and now over the wireless, not so royal proclamations and orders of a food controller and so forth. There must be promulgation and publication in their cases. The mode of publication can vary. What is a good method in one country may not necessarily be the best in another, but reasonable publication of some sort there must be.
I decided one matter sitting single under the Black Money Act. Appeal is pending. That was a e-gazette.
Your Lordship held that it is directory.
No,
Mandatory.
I held in favor of this,
Then my submission stand fortified, my lord.
but we are a division bench. We'll take a different. No, this now after the e-gazette, etc.
But the e-gazette, my lord, one more thing. It's very interesting. My lord, if your Lordship can take the evidence.
No,
act
one
for
thing
once.
Mr. Kundalya can verify.
Yes, yes.
That, in fact, what they say is it's a common order passed by the tribunal. Lead case is
Kothari. Kothari.
Kothari products, and they filed appeal before the Guwahati High Court. Appeal has been dismissed in 2017. 2012.
My lord.
So whether you can verify whether any appeal to Supreme Court against this order.
That one.
Number one. Second is we find in section 35 B1B.
I'm so sorry, my it was dismissed in 2010, in fact.
2010.
2010. I'm so sorry.
Reported in 2012.
2012.
35B1B. The word in the notification published in the official gazette has been removed and said by order. But that amendment came into force only in 2014. This period is prior to that.
My lord.
Thirdly, we are just thinking aloud that this is a curable defect. Assuming these commissioners were not notified at that point of time, the government or the department can now, board can notify, publish in the gazette. Then a fresh proceedings can always be taken, subject to law of limitation.
Yes.
My lord.
Whether that exercise had been done.
Cannot.
If that is done, this becomes an academic exercise. We need not decide that.
My lord.
Well, as failed from my lord, if your Lordship kindly takes the Evidence Act for once, একবার একটু Evidence Act দেবেন?
Evidence Act দিন।
Evidence Act. Evidence Act আছে? জিজ্ঞেস করতে এতক্ষণ?
34 আমরা করছি না, এখনো করছি। আপনি চলে একটু তখন রেখেছি আবার।
Yes, Mr. Mojumdar.
Well, if your Lord,
Judgment in the Honorable Supreme Court's judgment, kindly come to paragraph 3. What was the issue therein?
yes, I'm
The issue was when the notification comes into force,
right.
not that whether it is mandatory or whether it can be a curable one.
Yes. My lord,
So when it comes into force, that was the issue. Kindly come to paragraph 3.
right, my
That
lord.
was the
It has to
decision
be,
of the division bench.
it has to be made available in the sales counter.
Yes.
But that was the issue. My lord, but my lord, kindly visualize if that is the issue, the first precondition is publication in the official gazette, and then only the official gazette can be made available for sales across the sales counters. My lord, in this case, in my case, the first condition has not been fulfilled. Kindly take, my lord, only, my lord, apropos what has fallen from my lord. I think it is section 8 Evidence Act.
Next matter is mine, the similar issue. The question before
Same order, common order.
the question before your lordship, when we have published in the website matter, they have not. Now, whether they have applied before the authority concerned to purchase the sale at the same time.
Yes.
No, it is only.
No.
Has not.
Offered for sale.
They are saying it has to be published in the gazette and then.
Made available for sale.
Made available for sale.
If he wants, he can buy.
Right, the question before your lordship, when it has been wide publication and it has been uploaded in the computer, then they can avail it. They can avail it,
My lord, this is a question, my lord, but if Mr. Mighty suggests so, kindly take section 81 and 81A of the Evidence Act. 81 speaks of publication in gazettes. 81A, my lord, with the amendment, with the introduction of this Information Technology Act, we have now 81A, that is e-gazette. It was not an e-gazette. It may have been uploaded in the website, but that is not a curable action.
Get instruction in the matter. Two matters.
Yes.
Both the matters.
32 mine. My matter is 32.
You please give copy of this.
Well, I have already.
Kotari
Well, I have shared copy. Grateful, man.
We have heard so and so. It is submitted by the learned senior advocate appearing for the respondent assessee that the tribunal disposed of by a common order 6 appeals. And the lead case was Messrs. Kotari Products Limited. Against the impugned order passed by the tribunal, the revenue preferred appeal before the High Court of Guwahati, and the appeal was dismissed by the division bench as reported in 2012 278 ELT 43 within bracket Guwahati, within inverted comma, I'm sorry, within bracket Union of India versus Kotari Products Limited, bracket closed. The learned senior standing counsel for the appellants are directed to verify whether any appeal has been preferred against the said decision of the High Court of Guwahati. Furthermore, we find that the respondent assessee has succeeded before the tribunal on a technical issue that the notification notifying the principal commissioners was not published in the official gazette as required under Rule
3, my lord.
3 within bracket 1. Rule 3 read with Rule 2 within bracket small f. It needs to be seen as to whether assuming the department has accepted the decision in Kotari Products, it has to be seen whether subsequently this alleged defect was cured.
Yes.
And notification was published in the official gazette. If that exercise was done and the committee of commissioners as constituted and notified had exercised their powers under section 35E subsequently, then there may not be a need to decide the question of law framed in this appeal.
Right.
The learned standing counsel for the appellant are directed to get necessary instructions from the department in this regard.
But your lordship is posting this matter, my lord.
After vacation, my lord. Oh, husband, the old matter getting first of all getting people, then getting they will come.
Mr. Mighty would help Mr. Kundoli.
Both of us know what difficulty we face.
Another question will be before your lordship, whether the tribunal has jurisdiction to decide this.
Yes, that is also there.
What is their jurisdiction to decide the matter? Whether they can go into this question.
If it is patently without jurisdiction,
yes,
the authority who exercises the power of review
But my jurisdiction is constant to this limit. How can I go beyond this?
No, one of the grounds raised is that the man who decided did not have jurisdiction.
Mr. Maiti is enlarging the jurisdictional fact.
That is not the question on which it was.
Yes, yes.
Similar order,
But
32.
32, my lord, I'm not, we are not there.
Grateful, man.
Grateful.
Not available. Okay, so we'll say GA stands disposed of. So item 30 and 32, this order, same order. Who will appear for the assessee in 32? Nobody is. Then, sir, 32, you don't show Mr. Mazmundar's appearance. Nilanjana and Mazmundar, only Mr. Maiti, sir. Same order can be.
Item number 31.
First time is coming. Agarwala and Company. Now, none appears for the appellant. Respondent, you will appear, Mr. Maiti. Mr. Sarkar was appearing earlier. SS Sarkar.
My lord, but this Journal of India Limited belongs to given 2013.
Which one?
Journal of India Limited. Come into liquidation way back in 2013.
Okay, none appears for the appellant. Dismiss for non-prosecution. Next.
Item number 33.
Write down, sir. None appeared for the appellant. This appeal has been in the list since February 2023. And therefore, assessee had sufficient notice that the matter would be taken up for hearing. Dismissed. Next.
Item number 34.
33. No? 33.
Item 33.
This is N.K. Chaudhary appeal. None appears for the appellant. The appeal, this appeal filed by the assessee under section 35 capital G of the Central Excise Act 1944 is directed against the order passed by the Customs Excise Service Tax Appellate Tribunal, East Regional Bench, Kolkata. In SP number 267 of 2008 dated 12/6/2008. The appeal was admitted on 2nd September 2009 on the following substantial question of law. Page number 61, sir, only one question. Initially, you don't say none appear. The first line you strike it. The issue involved in this appeal is whether the tribunal was right in affirming the order passed by the authorities imposing penalty levying penalty apart from demanding duty. The contention of the appellant before the tribunal was the delay in payment was on account of financial difficulties and prayed for waiver of the penalty altogether. The learned tribunal rightly noted the decision of the Honorable Supreme Court in Union of India versus Dharmendra Textile Processes 2008 231 ELT 3 within bracket SC. And dismiss the appeal. We find no error in the order passed by the learned tribunal. Accordingly, appeal feels dismissed. Substantial question of law answered against the assessor. Next.
Item number 34.
Kaushik De. What, Mr. Maiti, you are appearing? None appeared, none appeared. Justice Girish Chandra Gupta. Then before that, Chief Justice Mohit Shah. I think you only appeared for us. There is some interim order also granted. Then who will appear for you don't have the papers. Your name is printed bold letters.
That is a read court, my lord.
Huh?
That is before the honorable read court.
No, no. In this appeal.
In this appeal.
Yes, your name is there in the paper book. Along with the Justice Bharadwaj, you had appealed. Let it continue in the list, we'll see. None appears for the appellant. Let the matter remain in the list. Now he's become standing also. Kaushik they can't appear.
He is now in panel.
None appears for the appellant. We find from the records that the learned advocate who was appearing for the appellant has now become a standing counsel for the department, and consequently he cannot appear in the matter. We have heard Mr. K.K. Maiti, learned advocate representing the respondent department. Let administrative notice be sent to the appellant by the registry. List the matter in the monthly list of July.
Item number 35.
Ashok Bhattacharjee. The remand order. They granted some relief and they said penalty is disproportionate and sent it back. All right, we'll stop. None appears for the appellant. Let it continue in the list. One more matter you call.
Item number 36.
My lord, in this matter, I am appearing for the respondent in this matter. My lord, the issue is Rule 83A of the Central Excise that is pending before the Honorable Supreme Court. Your Lordship.
What is the question on which it was admitted?
My lord, they have utilized the Senbet credit without paying the same. And in terms of Rule 83 of the Senbet credit, your Lordship knows unless and until they pay the same.
No, this is some 11 AC.
11A is in my lord. That is not the question. Kindly see the order of the learned tribunal, my lord.
The question admitted is whether the tribunal below committed substantial error in dismissing the appeal filed by the appellant on the question of imposition of penalty under 11 AC when there was no determination of duty under 11A2. That's the only question.
My lord, then my lord, I am entitled to this. I have the decision. Your Lordship knows the penalty cannot be waived, my lord. A judgment gulo tha.
Where is the order of the tribunal page?
My lord, that is after my lord. No, paper book. My lord, 49. Oh, no, sorry, my lord, sorry.
16.
50. 60 কোথায় দেবেন? Oh.
No, this is pre-deposit order.
No, my lord, that is order on 14th January 2011. 14th January, final order.
Page number is not there in. Page 10. Page 10. Page 13, last paragraph. Paragraph 7. All right. In the tribunal says in the assessee's own case, same issue dismissed. And in the grounds, we don't know whether they have raised.
Yes, ma'am.
Vijit Day. There is some injunction order has been granted. Stay order has been granted. Where is Prithu Doria is here? He appeared for the appellant. None appears for the, you inform him.
My lord.
None appears for the appellant. Let the matter continue to remain in the list.
My lord, I am praying on next Wednesday. Next Wednesday.
None appears for appellant June.
June. My lord. Deputy. এটা হচ্ছে 36
Afternoon, same country. Appellant side. That is appellant. Resident.
leave my lord to file a extreme urgent matter, file a appeal, my lord. Yesterday judgment was delivered, my lord, giving my lord with direction of the my lord, the CSC, my lord, to give electric connection within 7 days, my lord, with the police help in my premises, my lord. The petitioner no a connection with the said premises, my
Yes,
lord.
yes, leave ground.
My lord, leave it.
Please call the list.
Leave ground.
Appellate side, daily list, serial number 1.
That I appear on behalf of the CSC in this.
I am for the appellant. My lord, kindly see the order passed by the honorable single bench.
But there is no material to show that you are an independent possession.
My lord,
Ah.
appellate petitioner is the resident of first floor and father is the ground floor. And there is only 1 meter in the said house. My client applied for separate connection. Against that, we came before this honorable court and there is a direction to go before the GRO, the ombudsman. We gone there, but my lord Kalisi, section 43 of the Electricity Act, it will clear that a occupier has a right to get separate dividend. Kindly see section 43 of the.
But the learned judge, after going through the findings of the GRO,
Yes.
Says
That
that
regulation
Well,
cannot
kindly
override
take
the
page
act.
16.
Kindly see section 43.
owner or occupier.
Oh, so I am the occupant. I have annexed the voter card, other card in the writ petition and the appeal also.
But you should be in separate possession.
Well, kindly take page 16 of
Dada aage bolte the.
You should be able to, because it's the learned judge says, you come to page 3 of the order.
Yes.
And ombudsman have found that the petitioner has failed to show anything to prove his separate possession in the premises.
Ground floor and first floor.
Maybe, but still it is,
One premises.
no, one building.
One premises, 2 portion, ground floor and the first floor. And fighting between father and.
No, if you let us say, you have been leased out the premises or there is some document in your favor, then you can show that you are separate.
No, documents.
Property
really-
is owned by the father. It's a dispute between father and son. And splitting up of the load, he says there will be a problem.
Yes. Manoj, that is the reason I was referring to page 16. Manoj, kindly come what the petitioner has said before the GRO. Point number D at page 16. On this.
On being questioned with the ownership, petitioner said he does
That
not
is
have
right.
any documents.
The entire
That-
property stands in the name of the father.
That is not disputed. But is there any civil proceedings pending?
Nothing.
Then why your client is fighting with his father? Old man.
Well, difficulty is
If
the
he-
father and the.
Yes, Mr. Mukherjee, where is the larger being judgment of our court? Occupier is entitled to.
This occupier, we will take the occupier when we will
Was the larger being judgment?
larger judgment I don't have right now, but kindly see clause 14. May I hand over, madam?
Why have you not made the father a party? Your dispute is with the father. You have not made father a party.
Not between the father,
Yes,
dispute
yes.
is really.
Yes,
Father is enjoying, father is enjoying a electricity
separate
supply.
supply.
Their objection is that
No,
you
their
are trying
objection
to,
is splitting of load.
their objection is that you are trying to split up the load. So if that is so, father is a necessary party.
If my lord,
Direction, I have given
direction can be given, we can add them part.
earlier
You have added the father as a party. Your dispute is with the father.
Even before the GRO, he should have been a party.
Clause 40, subsequently I have also handed over the amendment, but earlier it was before the ombudsman, now it was before the GRO. Both the GRO and the ombudsman are held, my lord. He has failed to produce any separate accommodation.
Mr. Mukherjee, this is with the object intention of splitting up the.
Yes, my lord. He is already deriving supply.
He wants a separate connection
Yes.
stating that he is in occupation of a
But
separate.
my lord, I appreciate, my lord, but
And the occupier under section 43 is entitled to.
occupier has to produce some document.
No, have you got a ration card?
There is no document.
We have annexed voter card, Aadhaar card, we have annexed.
And this is not
Are
totally.
you disputing his occupation in the premises?
My lord, he has, my lord, we have asked
Are
for
you
document.
disputing his occupation in
We
the
have asked for
premises?
document, my lord. He has not produced any document, and the owner of the property was never brought into on record.
No, ownership is not disputed, Mr. Mukherjee. Father is the owner of the property. That he is not disputing.
My lord.
But he is residing in a portion of the property.
My lord, son will reside with the father, but my
Yes,
lord,
yes.
but without the, my lord, he has applied.
Your regulation 14, that
Yes.
is with regard to, with an
Splitting of-
intention of splitting of the load.
Yes, he has applied for new connection. My lord, how can we give in a one building, my lord, how can we? In one premises, how can we give 2 meters?
But as of now, he's got electricity.
Where from you are enjoying electricity? You are without electricity or you are.
No,
And that is our instruction is without electricity.
My lord,
Where have you stated in the writ petition that you are without electricity?
My lord, we have stated.
That much we can do. That I think is not
Yes,
really.
we
You
have
have not annexed the writ petition.
Well, ombudsman GRO
lord,
has specifically
page
told that he
4,
is deriving supply from
page
his
4
father.
in the stay application, K, middle portion of the page 4, that your petitioner is without electricity. For that, your petitioner applied for new electric.
No, you will get electricity from the same meter. Unless, suppose you have a lease deed, or father has given you saying that you can be in separate occupation of the first floor premises.
Any separate position.
Mr. Mukherjee, don't you have regulations for submitters, installation of submitters?
No, man. Regarding this splitting of road, man, we cannot, man, we don't have some.
No, it is not splitting up of load. The original meter will record the entire consumption. And if it is separate submitter will record the consumption so far as that
We
particular
have
portion.
concept of submeter in respect of block meters where we give, man. Regarding only loop meters, man, we don't have concept for submeter. And my lord, it has been categorically held. We have inspected before raising this issue of clause 14 that he is deriving supply from his father. And that has been also been.
Mr. Mukherjee, what document you have to show that he is still enjoying electric supply?
My lord, it has been recorded.
Have you inspected?
Yes, my lord. Before when he applied, my lord, we went for inspection. When we went for inspection, we have raised a letter stating that you are attempting for splitting of load because you are deriving supply.
That he is enjoying electric supply through that meter.
Yes, that has been categorically, my lord, that is the order of the GRO that we have stated.
Show us that.
I kindly see page 16. The clause B, The petitioner stays on the first floor of the two-story building and is presently getting supply from the meter of his father, Alok Kumar Chaudhary. Then, my lord, will kindly come to the final order, my lord, that is that.
But Mr. Mukherjee, kindly place the next sentence of that paragraph.
My lord. But presently
to
some
place it
dispute is
as a
going on
whole.
between the father.
So,
My lord,
so
my lord,
there is a, Mr. Mukherjee, kindly take a pragmatic view of this matter. There is a dispute between the father and
Yes.
son. It is also recorded that the father, sometimes switches off the supply.
my lord, if this,
That is so. What is the harm in giving the new meter? You will be getting charges for that.
no, my lord, we cannot deviate the regulation. My lord, while this point was raised before the learned single judge, and the learned single judge asked them to ventilate their grievances before the civil court, because the dispute is in civil nature, not in respect of the electricity. Kindly see the order.
Civil nature, what civil nature?
That has been recorded.
Electricity is a civil dispute.
My lord, kindly see. When whatever may be the mutual understanding between the petitioner and his father, the same is the subject matter of private civil dispute between them.
That is with regard to their private dispute,
Yes.
not with regard to the consumption of electricity. That cannot be a civil dispute.
My lord, I appreciate. My
Now
lord,
he has approached the Reed Court with regard to the consumption of electricity. That cannot be a civil dispute. And we have not made the father a party.
That is our mistake.
That is very important. He is the, according to you, he is the troublemonger.
My lord,
He will
but
regret.
you can
My lord,
give
even
me
we have,
my
even my lord, I can understand the dispute also, my lord, which has been raised here. My lord, he has not produced any single document, nor before the Reed.
What document he can produce?
Well, about his possession also he has not.
Yes,
told.
yes, that is
Yes, what
addiction.
is the document showing that you are possessing that
My
property?
lord, kindly see the annexure P1, page 8. This is my voter card. Next page is my next page, annexure P, page 9. This is my Aadhaar card. Everything is disclosing that.
The same occupation, my lord, how can we produce 2 meters, my lord?
You implead the father.
My.
The petitioner is directed to implead the father of the petitioner as a respondent in this. List the matter immediately after such application is filed.
My.
Serial number 2.
Since it has been alleged by the appellant that the father is creating disturbances in the matter of enjoyment of electricity through the meter in question. One of a continuation.
Well, I have submitted the regulations that will let it be the part of the.
You can take back, you can file it on, and also bring the larger bank judgment.
And I will bring the larger bench judgment, also a judgment passed by your lordship. On splitting out flood, I will bring. My lord, let it be with the record, my lord.
My lord.
Let it be.
Wait. You take it.
My lord, I'll add father in this. My-
আরো একটা আরো দুটো দিয়েছে আর দুটো দিয়েছিলেন
Yes, larger benches of the circuit bench at Port Bay. Bring that.
I will search and bring it.
So we are bound by that.
My lord,
The 3 judge bench judge.
I'll bring it. I'm grateful.
Serial number 2.
My lord, this is my opinion. My lord, we have served, my lord, with respect to the private respondent, it has come back.
What is the endorsement?
My lord, they have refused to accept it.
Refuse, then no problem. It is deemed service.
My lord, the crux of the case is, my lord, this is a matter, my lord, wherein for non-registration of a complaint with respect to a cognizable offense, my lord, this writ was preferred. Now, my lord, I would just straight away take your lordship to the order which we have assailed before your lordship. That's with the memorandum of appeal. My lord, this order, after I read, my lord, this is absolutely in contrary to the ratio which has been laid down in Lalita Kumari. My lord, I shall demonstrate. My lord, may I read? Your lordship has got it?
Yes.
The petitioners are aggrieved by the fact that the Pragati Maidan Police Station, Kolkata, has not taken any steps despite a complaint dated 2nd March 2022 against Chandan Pal, an ex-employee. Officer in charge, Pragati Maidan Police Station, has filed a report dated 9th February 2023, and the same is taken on record. It appears from the report that the only allegation in the said is that the said Chandan Pal has used a letterhead of the company forging their signatures to indicate that he has resigned from the said company and has been relieved. The police did not find any, my lord, I pause here, kindly mark this word, serious cognizable offense. My lord, there is no word serious, my lord, with due respect, my lord, and deepest humility, under section 154(1) of the Code of Criminal Procedure. My lord, if there is a cognizable offense or it is a non-cognizable offense. Now, my lord, in case it is a cognizable offense, my lord, the procedure is
You're appealing for state.
state.
But it was dismissed at the admission stage.
My lord, it was dismissed at admission stage, my lord. At that juncture, my lord, the police officers were themselves appearing and handing over that notes, my lord. We have also that instruction which we have appended to the.
It's an allegation of the complaint is that of forgery. So if forgery needs to be investigated, that fellow's employee has used the letterhead of the company.
My lord, and I am just taking your lordship to the complaint. We shall explain.
So
it
show
further.
that letter.
Yes, my lord, of the police.
No,
of the
that
company.
employee.
Very well, my lord. The letter, my lord, which has been forged, that is, my lord, a part of the next year, that is page 44 of the stay application, which is before your lordships. My lord, kindly sees the company seal, signature of the managing director, everything has been fabricated. Now, my lord, if your lordship so desires, my lord, we can again notify the state and come back, or else, my lord, if he is there, my lord, we can proceed, my lord. My lord, two judgments I would like to rely on. My lord, first is my lord Lalita Kumari.
No, Mr. Mukherjee, what will you take the complaint on file? Let them investigate and because it's yes,
My lord, paragraph 44 onwards, your lordship has already read this many times, my lord. Just for my satisfaction, I'm handing it over.
No, for
And my lord,
44 I have not read.
my lord, 44 starts with, my lord, the interpretation with respect to the applicability and whether, my lord, 154, when it is a cognizable offense, that's mandatory or not. Or whether the police has any discretion by invoking Police Act to make an inquiry and then come back and do everything, if it is a cognizable offense. These are the broader thing which has been dealt with, my lord, 44 onwards. And my lord, the other aspect, my lord, FIR cannot be, my lord.
From paragraph 120 of that judgment.
My lord, I am.
Wherein the conclusions have been summarized.
My lord, my lord. So, my lord, the registration of FIR is mandatory under section
120.1 would be relevant in your case.
Yes, please come. This intra-court appeal by the writ petitioner is directed against the order dated 13th February 2023. The appellant approached the writ court with a grievance that the Pragati Maidan Police Station, Kolkata, has not taken any steps on the complaint dated 2nd March 2022, lodged by the appellant against an ex-employee who had used the letterhead of the appellant company, forged the signature of the managing director, and in the said letter it is stated as if the resignation letter given by the ex-employee dated 12th August 2021 is accepted. The learned single bench was of the view that the learned single bench took note of a report filed by the officer in charge of the Pragati Maidan Police Station dated 9th February 2023, which appears to have been submitted by the police authorities by appearing in person before the learned writ court, and has opined that the police did not find any serious cognizable offense to be investigated. In our view, the allegation of forgery is undoubtedly allegation of forgery, if proved, is undoubtedly a cognizable offense. Therefore, in terms of the mandate in the of the Hon'ble Supreme Court in Lalita Kumari versus Government of Uttar Pradesh others, 2014 2 SEC page 1, comma, the registration of FIR is mandatory under section 154 of the code, comma, if information discloses commission of a cognizable offense and no preliminary inquiry is permissible in such a situation. In all probabilities, the respondent police were unaware of the legal position. The private respondent, namely the person against whom the complaint was lodged, has been served, has been impleaded as the sixth respondent in the appeal, and notice sent to the sixth respondent as returned with a postal endorsement refused, which is deemed service. We have requested Mr. Mukherjee, learned advocate appearing for the state, to accept notice on behalf of the official respondents. In the light of the above, there will be a direction to the fifth respondent, officer in charge, Pragati Maidan Police Station, Kolkata, to take the complaint on file, register an FIR, and investigate into the matter and take the proceedings to the logical end. This direction be complied with within 10 days from the date of receipt of the server copy of this order. Next.
Give him a copy of the writ petition.
Well, we have already handed over.
Serial number 3.
Appeal allowed with the above direction. Next.
I beg to appear on behalf of the petitioners. Lord, the third parties, Lord, it is an application seeking Lord leave to intervene. Lord, your Lordship kindly copy could not be served, copy and notice could not be served. Your Lordship kindly adjourn the matter, Lord, next Wednesday.
Who has not been served?
Lord.
Private respondent.
Private respondents.
What is the dispute?
Dispute,
From
Lord,
Muttawalli.
the property, Lord, in question every year. There is a Pir Sahib. Every year annual festival is held. Lord, since 2009 there is a dispute with the Lord the writ petitioner. This is the respondent number 1.
No, you can file a seek for some interim direction in the pending civil suit. For this festival, please make this arrangement.
Yes.
That you can pray for. How a writ court will interfere when the matter is seized of its.
The writ court has not restrained that everything was arranged from 17 to 19. All authorities granted permission. Writ court has not stopped everything. And we are the Lord Sevaites, Lord recorded Sevaites of that particular Pir Sahib, the Khadims.
All right.
That's why, Lord, Lordship kindly.
The counsel appearing for the petitioner is appellant is directed to serve notice on all the private respondents and file affidavit of service. As soon as the affidavit of service is filed, matter will be listed under the same caption. Next.
Serial number 4.
Thank you.
Good.
If it pleases your lordships, I beg to appear for the petition as well.
Hmm.
I am led by Mr. Shorak Chatterjee.
Takes to appear on behalf of the respondent number 7 and 8.
I will be humbly beseeching your lordships to grant me a week's accommodation, my lord. It commences to your lordships, my lord.
But in a writ proceedings, how to quash an FIR?
Yes. My lord, since I am beseeching your lordships for a week's accommodation.
No, then you should not have moved the matter, should not have filed the matter. What is the date you wanted the matter to be listed? To be listed on 26/4. You be thankful that the matter is listed.
My lord,
every day people are coming and mentioning. You do one thing, same paper book, same stay application, convert it into 482 and file.
My lord, may kindly take up, my lord, kindly grant me a week's
No,
accommodation. My lord.
This intra-court appeal.
My lord,
is
then permit me to place my case, my lord.
yes, that will be better. Please, please.
My lord, may kindly take up the impugned judgment.
Yes.
That will be at page 300 of the stay application. My lord.
It's also
Would be, my lord, page 342. My lord. 342.
Hmm.
My lord, the petitioner prays for quashing of the FIR being Sakrail police station case number so and so, my lord. My lord, here I will join issue on the first sentence itself, my lord. My prayers are not limited, my lord, to quashing of the FIR.
Then you file a review.
Instead, my lord, may I suggest one thing, my lord? My lord, may kindly set aside that order and direct me to the learned single bench to.
If according to you there's an error
my lord,
apparent on the face of the order,
my lord,
the remedy.
My lord, that's one, my lord. Kindly,
Enough, sir, enough, sir.
my lord, kindly allow me to place the judgments, Honorable Supreme Court judgments, my lord.
Not required. This intra-court appeal is directed against order dated 11th April 2023. By the said order, the learned writ court dismissed the writ petition on the ground that writ petition is not the remedy to quash an FIR. The learned advocate for the appellant would vehemently contend that that was not the only prayer in the writ petition. If in the opinion of the petitioner, appellant, that there is any error in the order passed in the writ petition, appeal is not the remedy. And the avenue open to the appellant is to file a review application and make out a case before the very same court that the order suffers from errors apparent on the face of the order. Thus, at this juncture, we do not find any grounds to interfere with the order passed in the writ petition. Appeal fails, dismissed. Next.
Serial number 5.
Grateful, my lord.
Sorry.
My lord, our presence can be noted, my lord, for the respondent number 7.
University of Burdwan.
As per your lordship leave granted, I filed it.
Very good.
I prepared the stay application today and I got it affirmed only on today. Kindly
No copy of the memo as well as no copy of the stay of application.
I could not serve it because I could not file it. I was fallen ill. That is why I could not.
No problem. Everybody is falling ill because of the weather. Today is suddenly raining.
I could prepare it and affirm it today only.
34 lakhs of petitioners already collected approximately.
There are so many documents to have been collected.
Now, you are for the. No, the matter is still pending before the learned single bench. But he directed
me
50%.
50% of the third arrangement. That third arrangement, why could not be paid? There is an ask in totality. Neither the tender was invited in correct position. Violation of the government order that above 5 lakhs, no tender can be invited without e-tendering. And quotation was invited without sign. And that doesn't order.
Oh, who invited the quotation? Who accepted?
University engineer.
Pardon?
Bardhaman University engineer invited the quotation.
The work order was issued. I completed the first phase of the work. Thereafter, second work order was issued. I completed a part of the work. First RA bill, running adjustment bill has been paid without no objection. Second RA bill has been paid without no objection. Third RA bill has been submitted, approved without assigning reason, withholding that money without assigning any reason.
I should submit the original history.
No, the thing
quotation was not signed by the company. And the applicator of the company was awarded the contract without getting it signed.
After completion of the work.
This contract is said to have been awarded in the year 2014. We've been doing all these years.
No.
You should have suspended your engineer.
Yes. That could not be caught.
He has done the work.
No, he has not done this work. He has not completed all the works. He has been given 3 work orders. On the basis of quotation has not been signed. And the formal agreement, yes, he has agreed for only one item.
We will come back to you.
Yes.
But essentially, the dispute is contractual.
My lord.
In terms of the contract, if suppose there are certain conditions, non-fulfillment, they can withhold payment, they can, adjust from the security deposit. There may be an arbitration clause. But how do you bring it within the writ jurisdiction?
Yes, there is an arbitration clause.
I'm coming to that, man. I do not know what grounds has been taken as well as the order.
2017. Money claim lying due since 2017. Writ petition filed in 2023. It's barred by limitation. How can we enforce that?
Work order, the work order that was issued still continue. I am
money-
continuing the work.
We appreciate
I am
all
continuing
this,
the work.
but the money which is lying due and outstanding from 2017 in a writ petition filed in 2023.
Several representation before the authority concerned. I am still continuing the work till today. No allegation has been raised by the university engineer till today. Now, before the honorable court, they have been submitting before.
No, one thing, sir. Before anything can be done, maintainability of the writ petition has to be decided. He may be a creator of a statute. He may be an university. He may have his own act, etc. That by itself cannot bring this dispute within the realm of Article 226.
But may I pray one thing before my lord? Kindly direct them to serve a copy of the
No,
memo
what
of
we'll
appeal,
do
and
is,
I will come back on tomorrow, my lord, on tomorrow to argue the case.
no, what we can do is,
What grounds they have taken now?
nothing, without his grounds, what we can do is, we'll direct the learned single bench to consider the question of maintainability on the next hearing, because the matter has been fixed on 3 weeks. 3 weeks since 17/4. Probably immediately on reopening, or it should have come.
My lord.
Let the maintainability issue be actually.
My lord. But no restraining order in respect of the interim order that was passed, that is.
The
No,
Vice Chancellor has got no
I have
financial
invested
capacity.
huge amount of money. I have invested 1 crore tender, rupees 1 crore. I have invested huge amount of money out of that 35 lakhs.
Well, the Vice Chancellor at
There is
present
a
has not
dispute.
got
If
no
my lord
financial
so
capacity.
pleases to pass an interim order staying the operation of the
How can a
order.
part payment be directed without deciding the issue of maintainability? And when it's a disputed
That
claim,
point has not never been raised before the honorable judge.
so you file your stay application. File your stay application.
And direct them to serve a copy. Thereafter, we will make our submission.
Deeply obliged.
Asun. The learned advocate appearing for the appellant university prays for time to file the application for stay. Yes, when can you file?
Today as well.
List this
I
matter
got it affirmed in the morning.
under the same heading on Wednesday.
Yes, ma'am.
On next Wednesday. My lord.
Obliged, ma'am.
Serial number 6. Lord, I am for the appellant. The present appeal and stay application arises out of the order of the single judge, where the honorable single judge at the threshold, without even inviting orders for affidavits, has, my lord, made such an aspersions against the petitioner, and my lord held on entire factual aspect without even inviting affidavits against the writ petitioner and dismiss the writ petition. But kindly comes to the, my lord, order impugned, which your lordships will find, my lord, appended to the memo, Lord, and also in the application, my lord, I would like to, my lord, place it from the memorandum. Lord, kindly takes, my lord, there's an order of 11th April 2023. My lord, kindly see the second paragraph in the order. In fact, suspicion of racial discrimination cannot be ruled out, keeping in view the names of the petitioner and the private respondent. Lord, at the threshold, without affidavits. My lord,
And what was the relief sought for? In the-
yes, relief, my lord. I'll tell your lordship the brief facts, absolutely brief facts. My lord, the writ petitioner before your lordship is an owner of a premises in central Calcutta. The private respondent runs a restaurant called Tibetan Delight from that property. Allegation is that the private respondent, in order to run that restaurant, has hooked electricity or used unauthorized electricity from the adjacent premises of Mr. Ashok Mansata, who is also a writ petitioner in one of the earlier rounds. Now, my lord, both the adjacent owner from whose premises the line had been hooked, unauthorized hooking was taking place, and my client, the writ petitioner in this writ petition, my lord, were parties in the earlier round of litigation between the Tibetan Delight's owner and Mr. Ashok Mansata. My lord, the court has, this very self-same judge has found that the Tibetan Delight, that restaurant's owner, has used, my lord, the electricity connection all this while unauthorizedly, and had directed the CESC authorities to issue proceedings under 136 and 125 of the Electricity Act for unauthorized use and theft. 125 and 136. Now, my lord, my allegation as the landowner of the property in which this unauthorized act has taken place for years together in this writ petition is that the provisional order and the final order that the CESC has issued under section 125, they have levied fine on the restaurant holder only for 55 days. Whereas admittedly, my lord, the CSC itself, which is a part of the writ petition and the supplementary affidavit, CSC themselves by letter as back as in 2020 and 2022 has told that restaurant on record that you are unauthorizedly using the premises and hooking electricity. Now, my lord, going just by that, it could not have been 55 days. So, my lord, I said this assessment is wrong. And my lord, there is already an order of the learned judge itself, trial judge who has taken this matter, that unless proceedings under 125 and 136 are completed and she complies with the order, no connection should be given to her. Now, my challenge in the writ petition was that this made by the CSC is wrong. It should have been much more. It should have been, admittedly, she is running that premises for 30 years or odd. Now I'm saying forget all that. At least CSC's letters on record, which from 2020 and 2022, those should be considered and a higher amount of fine should be imposed, because the purport of these sections is of deterrent effect against a person who is hooking or unauthorizedly using. And as a landowner, as the owner of the premises, I have been harassed. I have been made to run to court and defend all this.
But no part of the money is going to come to you.
Naturally, I don't want.
It is up to them to make the assessment based on records, based on their regulations, etc. That is one. Not to give electricity connection, maybe on certain other grounds. If suppose they pass an order, you cannot challenge the correctness of the order. You are the owner of the premises.
My lord.
The allegation is that of theft. It's a criminal offense.
My lord.
They can lodge an FIR, parallelly also proceed under the regulations.
Yes, my lord.
They might not have lodged an FIR, but they have proceeded under the rules and the regulations, initiated proceedings, determine the amount payable. But now indirectly, you are trying to file an appeal against that order by way of a writ petition.
No, I am challenging complete collusion between the CSC authorities and, my lord, the private respondent. They, my lord, on record when your letters are, Lord, kindly see,
No,
I have been dragged
this,
to
I
court.
think, appears to be a landlord-tenant dispute. in
No, my
Cameron.
lord, no, my lord. My lord, deepest of respect, kindly see the other orders of the same learned judge without affidavit. My lord, kindly appreciates one thing.
No,
I have
without-
filed a writ petition challenging, my lord, a validity of an assessment made by the CSC authorities without affidavits, calling for affidavits, without a single line.
Which rule says that?
My lord, without
there's a
single.
mandate that the writ court should call for.
Very
it.
well.
I think-
Now, my lord, kindly appreciate. Your lordships will scan the order in question in vain to find one line on the merits of my challenge. The learned judge, with the deepest of respect to the learned judge, kindly see how he has proceeded. He has proceeded on matters which are not part of the instant writ petition, which has gone by bygone era. My lord, he has brought in those orders, his own orders, reflection of those orders in the writ petition. My lord, he has proceeded on submissions from the bar. Kindly see now, may I place, my lord, internal page 3. May I place the whole order, my lord? Then your lordship will be, my lord, inside. My lord, page number 2, my lord, of the order. Last paragraph. In fact, CSC Limited, in view of the circumstances noted therein, were also directed to initiate a proceeding against the private respondent Nima Mukhi under section 135 of the 2003 Act, since as per allegations of CSC Limited and as per circumstances of the case, it was held to be evident that an unauthorized use of electricity was involved.
But he says he is the landlord.
Petitioner is the landlord of the adjacent premises.
That is absolutely wrong. I'm coming to that. That is absolutely wrong finding. I'm saying that without affidavit, how could he have come? I am the owner or landlord of the premises in question. Learned judge has recorded that I am the owner of the adjacent premises. But the whole order is based on that I am a busybody, I am nobody. Whereas my category case is that I am the landlord of that self-same premises. Self-same premises. But
now, the prayer in the writ petition was to disconnect the new metered connection if given to the private respondent in view of non-compliance of section 125 and 135. That is the first prayer. Second is to take steps against the owners of Tibetan Delight under 135 and 126. Now, the CSC has found that there is no theft of electricity.
No, they have found that there is unauthorized use.
All right, unauthorized use, they have made an assessment, final assessment.
Yes.
According to you, that assessment is thoroughly disproportionate to the allegation.
I'm so sorry, my lord. I'm so sorry, my lord. First, they read a provisional assessment.
Yes.
They give a date in the provisional order that the final hearing will be held on 6th of March. On 20th February, this provisional assessment is made. That final hearing, if you have any objection, give us. The final hearing will be on 6th of March. On 22nd February, within 2 days, we do not know what happened, final order comes. How may I ask to myself?
Let us see that final order.
Yes, my lord, also see the provisional order, my lord. Kindly come to, my lord, page 87 and then 88. Kindly see page 87, my lord. Page 87, my lord, is there. My lord, order of provisional assessment is there. The date is slightly, my lord,
20th of March.
yes, 20th February, my lord. It will be 20th of February. Is during my inspection of the aforesaid premises on 20th February 2023, I have come to the conclusion that unauthorized use of electricity was indulged as under. Srimati Nima Mukhia is the present user beneficiary of the meter bearing number such and such under consumer number such and such, standing in the name of late husband Uday Mukhia, was found extending the services in an unauthorized manner for her premises at 67 Chorongi Road to run her small eatery under the name and style of Tibetan Delight at premises number 66 by 1 Chorongi Road. So I am owner of 66 by 1. I have prepared a report of my inspection, copy of which is attached. Photographs have been taken during the such inspection, such and such. I have provisionally assessed to the best of my judgment the charges for unauthorized use of electricity to the tune of 12,429, inclusive of electricity duty as applicable payable to the state government as per details appearing below. Then, basis of assessment. Date of inspection is 20th February 2023. Reading of the said meter number such and such was not available due to denial of access to the service meter board. Next, last available meter reading is of 20th 12/2022, was recorded as 30487. As per clause 5.1 regulation 55 WBERC, assessed units towards authorized extension is to be considered to be the energy consumed as per meter reading between the date of final reading as available in the latest bill, which was raised prior to detection of this unauthorized use, and the date when such unauthorized use is detected. This is very important. When the unauthorized use is detected. Then see kindly the next paragraph. Therefore, period of unauthorized use of electricity considered is between 20th December 2022 and 20th February 2023. That is 55 days based on the date of inspection and the date of last available meter reading. Now, my lord, this is absolutely, thereafter he goes to the calculation. But my lord, kindly see the last line, last paragraph. You are given hearing by me on 6th March 2023 at 10 a.m. in my office, aforesaid address, before passing the final order. Now, my lord, at this stage, kindly reads, my lord, takes page 80. Page 80 of the set of the present petition, my lord. This is part of the supplementary affidavit filed before the writ court. Page 80, CESC's own letter of 23rd May 2022, telling the husband of the petitioner, of the private respondent, at
See,
page
the
80.
allegation is not theft. Allegation is unauthorized.
Yes, even unauthorized use, my lord, they are themselves are saying what is the date to be calculated, unauthorized use, detection of this unauthorized use, and the date of such unauthorized use is detected. Unauthorized, I'm sorry.
The husband of the private respondent was the beneficiary of the meter.
My lord.
Probably you have granted him permission as the owner of the premises to use the meter.
No, no meter. My lord, kindly appreciate one thing.
It says Srimati so and so.
My lord, that meter, my lord, is referring to is from another premises, not my premises at all. They have been hooking from up adjacent premises of Mr. Ashok Mansata, whose writ was also considered.
So therefore, the theft has occurred or unauthorized use from a different meter.
Meter, yes,
Therefore,
into my premises.
To your premises, but you are the adjacent owner.
No.
So far as that premises is concerned. So the learned judge is right in terming the appellant as an adjacent owner. Adjacent owner, these meter.
Lord, kindly see what the learned judges.
So now what happened is, this lady is running a restaurant in your premises.
Yes.
She's getting electricity from the neighbor. She is unauthorized. According to it has been drawn.
That is fact, admitted.
So therefore, they want to proceed against her or probably proceed against your neighbor. for having allowed her to draw.
No, they are proceeding against my tenant.
So he will pay.
No, my lord, kindly appreciate for this act of hers,
No,
I have been dragged to every forum, including defending this earlier writ petitions where she had made me a party. I did not come to court on my own volition. Kindly appreciate. The learned judge has completely misapplied himself with the deepest of respect.
No,
Lord, I did not come to court. Nima Mukhia, the owner of Tibetan Delight, had made me a party as the landlord and dragged me to court for years together. And I had to defend it, paying my good and well-earned money. And my premises, she has taken fire license, representing herself to be the owner. That I have to challenge now. She has taken, she's running a business.
Deep-rooted landlord-tenant relations.
Lord, kindly appreciate. It may be. There are a lot of things, my lord, where we only see the facade. But on law, on facts, if I have filed a writ petition challenging an assessment by an authority, I am saying orders are clear. I will show your lordship the orders which says clearly that they will assess, and also it goes on to say by the same judge that you will also initiate proceedings under 135 for theft, because he says unauthorized use at occasions can also be theft. So with all these allegations, not a single word your lordship will find why this challenge of mine is bad on the basis of 87 and 89.
You have no locus standi. You have no locus standi to question the provisional assessment or the final assessment order passed by CSC against the fifth respondent in respect of an allegation that she has unauthorizedly drawn electricity from a neighboring premises.
My lord, may
She may be.
My lord, I appreciate what is falling from your lordship. Kindly appreciate.
You get an order of eviction.
My lord, kindly appreciate.
You get an order of eviction. Throw this stadium.
That is different. That is different. My lord, kindly appreciate one thing. My premises has been used.
We will eschew whatever observations the learned judges made, etc.
And he has also made, my lord, passed an order of cost against me.
That we can delete. That's really
no, but really, the cost does not really hurt me, my lord. As a man,
then you pay. We'll increase.
No, my lord. That is not for what I am here.
No.
My lord, I want justice. My lord, I have been dragged to court. Lord, kindly see the other.
I'm praying for enhancement of cost.
Very well.
Because of huge harassment. I will show to your loss.
This is why.
Relying upon Salem Bar Association.
This is why I am saying CSC has now, my lord, made up with the private respondents. Lord, kindly see the other orders of the same judge. Now, my lord, kindly see the other orders. And my lord, the second paragraph of the order gives it away. My lord, without affidavit, this cannot. My lord, this shows that probably the honorable judge was, my lord, for some reason I don't know, my lord, was my lord, very, my lord, lopsided in his attitude, in his approach. But this itself, my lord, vitiates any other observations made by the honorable judge with the deepest of respect, my lord. I was not there. I must be candid before your lordship.
Then it's all the more your statements must be tempered. If you are not there,
that's what I'm saying. That's what I'm saying. I hedge my.
That's the risk you run by taking a change brief or taking a brief in which you did not appear before the original proceedings.
Yes.
You better be briefed about. You take.
But I have taken instruction.
Now that it is live stream, you see the video.
My lord, I've been very cautious, my lord. I've been very cautious, my lord. That's why I'm saying, my lord, this possibly.
No, you stand or fall by whatever has been recorded.
Exactly. So on record,
don't make such.
On record, there is nothing.
You argue your case based on the observations.
That's why I'm saying, my lord.
Saying that this is erroneous observation. This finding doesn't touch upon the facts.
This is what I said.
Yes.
The second paragraph does not have any base to stand upon.
That we already noted.
Yes.
You need not repeat.
Kindly see
Go to your next point.
Kindly come
First
to
point you have said that even before the date of personal hearing, final assessment has been passed, therefore collusion. Second, you have said the learned judge has made us a wrong observation that you are an owner of the adjacent property, erroneous, that we have taken note of.
Yes, now kindly takes page 80. Page 80.
And third, say your first submission was affidavit should have been called for, that you have
Yes, your lordship, kindly come to page 80.
80.
80.
Yes.
Lord, kindly see, this is, my lord, a notice issued by CSC. Issued by CSC upon the husband of the private respondent on the date is 23rd May 2022. Kindly see the contents of the letter. This is to inform you that a recent inspection carried out at premises number 67 Chaurangi Road revealed that you are illegally drawing electricity from meter number such and such installed at the said premises to Premises number 66/1 Chaurangi Road. Such illegal drawal of electricity falls within the mischief of unauthorized use of electricity as enshrined in 135. Now, my lord, so this date, your lordship kindly notes 23rd May 2022. My lord, now comes to page 224.
Yes.
Kindly sees again, my lord, CSC letter to, my lord, the husband of the private respondent, dated 3rd March 2020. Kindly see, during an inspection, it was observed that your installation did not comply with section 135 of Electricity Act in that, and that there is unauthorized extension from premises number 67 Chaurangi Road to 266/1. Please note, another inspection will be made in 7 days. So, my lord, as late back as on 3rd March 2020, CSC is aware that it is unauthorized. So, my lord, now kindly comes back to page 87, the order of provisional assessment.
It is only 28,
Only-
12, 20.
Yes, it is only 55 days. How? On the basis of the documents which are available to them. Now, where has the learned judge considered this? My lord,
Now, why have you restricted it only for this
Well,
55
I'm for
days?
the private respondent. Well, may I make one for some?
We'll hear, please. Why have you restricted it to only?
If your lordship can see section 126 for a moment.
What does it say?
May I? So far the connection is concerned, your lordship will find that it is the meter which belongs to the private respondent. It doesn't belongs to the either of the petitioner or it belongs to the private
They
respondent.
are clear on facts.
And on that they are, it's a, first of all, I raise the question of the locus standi. Now, next question is.
Answer the
Yes,
question.
yes, lordship
we have
kindly,
posed to you.
lordship kindly come to 126 for a moment. (126)(1), lordship. If on inspection of any place or premises or after inspection of the equipments, gadget, machine, device found connected or used, or after inspection of record maintained by any person, the assessing officer comes to the conclusion that such person is indulging in an unauthorized, he shall provisionally assess to the best of his judgment. So the best of this judgment, which who is the authority to decide? CSC authority is to decide, and there is a parameter of calculation which has been provided in regulation 5.1. Lordship, I am not equal in that parameter. If your lordship kindly see the assessment order for a moment. Final order of assessment, if your lordship kindly come.
Page 87 is provisional.
Page 87 is the provisional order of assessment.
Page
87 is the
88.
provisional. Yes,
88 is the final order.
is the final order of assessment. So far as the provisional order of assessment, lordship kindly come to page 87 for a moment.
Yes.
Now, to the best of the judgment, the assessment has been calculated. There is a parameter laid down on what basis the calculation is to be made. Now, on that basis, this regulation has been regulation 55 clause 5.1 provided the calculations on what basis the calculation has to be made. On that pretext, who is the authority who, to the best of his judgment, as the statute empowered him to make that calculations, he has made these calculations and he has come to this conclusion.
You are not worried about the arithmetics. His grievance is, as early as on 3rd March 2020, you deducted that there is unauthorized drawal of.
But so far the unauthorized is concerned, your lordship will find it has been specified from a specific meter from where this is the another thing. There are various kinds of pilferage. This is the case of an unauthorized use of electricity where they have already paid the amount. They have already paid the dues. So far from 2020 onwards.
No, the connection number is 6002, ending same connection number. 3rd March 2020.
I tell you, lordship.
You deducted. Where is the assessment order on that?
But
so every time he will draw unauthorizedly, every time you will assess, he will pay. You allow him to draw unauthorizedly.
No, that is.
He will keep him out of the picture. He's got no locus standi.
Lordship.
You are supposed to administer your business of, as a licensee,
Lordship.
as a licensor, under the provisions of the Act. And here is a consumer who has been repeatedly drawing from 2020 for the past 3 years. And you have condoned the lapse, is it? And you have restricted, what is best of judgment? What is best
I
judgment
tell
assessment?
you, Lordship.
What is best judgment assessment?
Base judgment assessment,
As per the, what does Supreme Court say? What is best judgment assessment? There is an element of guesswork in a best judgment assessment, but it can't be haphazard. It can't be a wild guess.
Lordship. I
Best
vote,
judgment assessment is you don't have material. Assessee doesn't cooperate. So therefore, we are not into arithmetics. We are on your conduct. This man has been drawing unauthorizedly from the connection from the neighboring property.
from his own meter,
Maybe.
from his own meter.
You do whatever it is.
And he has already paid the electricity bill, what has been drawn from that meter.
That is wrong. Sir, if he draws it within his premises, is fine. His wife is running a restaurant in the neighboring property owned by the appellant. From there, he draws the line across the property. And you say that I have paid the bill.
No, I have not said that, Lordship.
Why are you protecting him?
No, I am not protecting that. I am not.
You get your dues, sir. You get your dues. You have made a provisional assessment, made a final assessment for 55 days. What about the past period?
But so far the past period is concerned, your Lordship.
Unless you say, sir, we went and inspected. There was a prima facie view that they're unauthorized. Later we found there is no unauthorized use. Therefore, we dropped the proceedings. Is different. But he is producing some record to show that in March 2020, you found that there was unauthorized.
Well, Lordship, kindly appreciate that unauthorized assessment can be made when there is a loss of revenue. There are two aspects. When there is a loss of revenue, there is no such loss of revenue on the part of CSC authority. So far the payment is concerned, we got that.
Which provision says so?
Assessment.
No, which provision says so that if it is revenue neutral or that fellow throws up his hands and say, no, sir, I'll pay, I will condone.
No, I am not on that, Lordship. Lordship,
No, this is a very wrong argument. Appearing on behalf of a board is a very wrong submission because the supply is given strictly on conditions. License, it's a clear license agreement. So he has to stand or fall by the conditions. The condition will say that this is to be used for domestic purpose.
No, it's a commercial purpose.
All right, commercial
for
purpose.
commercial purpose.
Commercial purpose in premises number 66 or 65. The wife of the owner of the premises also runs a business in the next door number 66. How do you say that there is no revenue loss because they have paid the consumption charges? There is drawal of line to the neighboring property, which is violation of the license condition.
But that for that section 135 proceeding is to be laid down. We have already complained before the authority, and the police the police has to take steps on that.
What about your assessment?
But so far the assessment is concerned, your Lordship will find that they have specified the clause 5.1. That is a specific regulation.
I have that with your Lordship. The regulation is referring no such period of 55 days is. There's no 55 days period.
But there nothing.
No, I think it is a wrong understanding. The authority has probably done so because once unauthorized use was deducted, you are bound to proceed in.
Lordship, we are duty bound to that, and we are duty. We bow down to your Lordship observation also. We are duty bound to that.
Forget about him. But you are the licensor.
Lordship, licensee, Lordship.
So you are the person who is providing connection, and if the terms and conditions of license are violated, you are to take action. You found unauthorized use.
Lordship, I fully bow down to your Lordship.
That is wrong.
Yes.
I think they understood the provisions wrongly.
Lordship, kindly come to regulation 5.1. There is a specific.
He may not get a relief in this appeal. He did not get a relief in that.
Not
but
only,
so far as you are concerned,
I fully appreciate what has fallen for your Lordship. I bow down to your Lordship observation. But so far the expert knowledge is concerned, your Lordship, that is 5.1. May I place it for a moment?
Yes.
Regulation 5.1.
Yes.
May I please? There is parameter has been laid down.
Attempt to consume is also an offense.
5.5 next second part, your Lordship will find. It's offense. For this reason, we have made an assessment. But so far the calculation days is concerned, our lordship is on that.
Yes.
But this calculation of days is concerned.
Because unless you say the document at page number 224 is a forged document. During inspection, it was observed that your installation did not comply with 135(1)(c). In
Yes.
that, there is unauthorized extension from premises number 67 Chowringi Road.
Lordship.
Please note another inspection in 7 days. Defect has to be rectified. Whether they pulled it off within 7 days. If they pulled it off, that's a different matter.
But that has to be, that I have to take instruction. on
No,
that.
no, no.
Well, the way that they have.
We will impose this cost on you. We will impose this 50,000 cost on the board, on CESC.
Lordship, that is the criteria.
Payable to Legal Services Authority. We'll add one more zero.
Lordship, kindly appreciate. There is a
Sir.
specific regulation.
Have to disconnect the extension. Why are you begging before that fellow to say, you remove the installation? We will come back after 7 days. By then you consume another 10,000 units. And then I'll come back and say, all right, you have paid the bill. Very, very good. You continue with the unauthorized extension.
Kindly see 5.1(c).
Yes.
If any consumer extend the service from his own premises with service connection, has been able to take another premises where the licensee has disconnected the service. No, this is not applicable, Lordship.
This is
No, this is not applicable.
This is what you should have done.
This is not the 5.1(b). I stand correct.
5.1(c) you should have done.
B.
Unauthorized use of electricity is covered A,
Lordship.
B, C. Such case A will be applicable.
But there is a specific calculation has been laid down. Where if your Lordship kindly see
You
the
are refusing to
calculation.
understand. You are refusing to understand. What do you like to say, sir?
Give me 2 minutes time, my lord, I think. 67.
Clock starts now. It's 15:26.
But factually, certain things to be apprised to your lordships. 67 at the premises where our meter is installed in our name.
Your
We are the tenant. We are residing over there. That's a commercial meter. Commercial rate of charges is the highest.
Yes.
Industrial, then domestic. So while I am using as a domestic premises, I am paying at the commercial rate. That was one of the consideration by the assessing officer. Now, admittedly, there was an extension to the just nearby premises 66/1, where I am running a hotel. I have been knocking my head to the authorities and my learned friend's client to get a separate meter. I didn't get it because they all the time
They're
objecting and they are trying to oust me. Now, admittedly, I unauthorized. Now, considering this fact, your losses kindly consider 126(1), my lord, provisionally to the best of the judgment. If your losses borrow the judgment of the income tax, my lord, best judgment theory, with all the materials recorded that can be assumed, since I have been paying at the highest rate, and that is being consumed in recorded in the meter, my learned friend, to certain extent correct that CSC is not losing money, but they are all throughout getting electricity at the higher rate because it's a domestic premises.
This is unacceptable, sir. This argument is unacceptable. As a licensee,
I'm coming to that. I'm coming to that. My lord, extension is wrong. Extension is wrong. Then your losses kindly consider this aspect. What they at best can take your losses, penal rate. They are entitled to penal rate because whatever I have consumed, that has been admittedly recorded. There is no dispute. In penal rate consuming, my lord, they have, my lord, given certain relaxation because I have been all throughout paying at the highest rate, which I have to pay, my lord, at the lesser rate. Because I'm using that meter for domestic purpose, but I'm paying at the commercial rate.
That is, we can't change it, sir. With your eyes wide open, you went and.
But that's, my lord, the best judgment of the authority. That's the base
for commercial meter.
I beg.
You applied for commercial.
But I tell you loss.
Why did you apply for commercial?
But I tell you losses initially probably this is since long. Initially probably the restaurant would be open over there, but subsequently long time restaurant in the nearby building. This has been occupied. Malad, this doesn't affect anyone. CSC has not, Malad, suffered any loss either. So this is the one, your lordships. This is therefore your lordships.
We are not agreeable on.
Matlab, this is the thing, your lordship.
If you make an order, you file an appeal. We can't, but though the CSC has to redo the assessment. And one is, we are not about the amount. The interpretation given saying that I am enjoying in a commercial meter, from that I am paying high charges and I brought it here as a and I have paid the entire consumption charges here. Therefore, there is no loss for the CSC. That argument is wrong.
Matlab, I tell you, lordships, can it be entertained in this appeal?
Yes.
Who is aggrieved, my lord? Kindly consider this. My learned friend cannot be said to be aggrieved. That's why, my lord, kindly.
No, we will give our reasoning. We will reason out as to why, though he doesn't have a locus standi, why the court can do it. Because there is a public element involved in the supply of electricity. There is a public element involved.
Now, then your losses kindly consider. I could not get the supply. I had to.
You file a writ petition, you go before the.
But that's my writ petition. That was disposed of earlier. Kindly look
He
at
has a
it.
connection now.
I have connection after that order.
That is
After
true.
paying these.
So we are not worried. Nobody is disturbing your connection. It is regard to the period. Which, therefore, if a fact comes to the notice of the court in a proceedings, where the court may also consider the petitioner to have no locus standi, yet if there is a public element involved, the court is not powerless under 226 to set right the wrong. We can direct the board to say that, yes, what you did is wrong. You had kept sitting in the fence and watching, saying that you please disconnect within 7 days. I will come back after 7 days. And from 2020, this is going on. And they give you a concession because you are enjoying a commercial connection. That is your option.
No, I tell you, losses. This is a commercial connection. The charges only for the penal rate. That's your losses, my lord. Ultimately will jump down to the same. Only penal rate, little bit of exchange.
Conduct of the consumer from 2020, 3 years. Despite your earlier notice, still the offense continues.
No. I could not run for a certain time. This was before the assessing officer.
So therefore,
So this is not before your lordship.
no, in the assessment order,
Yes,
the
your lordship.
period is 26.
55 days confined to.
It can't
50
be
days confined to.
because the order at page.
No, your losses from 2020, the entire period is lockdown period.
That is different.
How do I get it? That's why.
So,
kindly consider. That's why the last date of inspection was considered.
Lord, may I only make one more submission?
Now your lordship,
I
visualize
heard
your lordship.
only two
Can it
for
be
the
gone into
assessment
this
of the
writ
court.
petition?
Lord, kindly comes to page 48. My learned friend's entire argument now will fall through. 48, 47 and 48. His predecessor, her husband filed a writ petition in 1997 for a new meter.
Yes.
So from 1997, he has been doing this. Not from 2 years. I only showed the document of CSC to show that CSC knows. Kindly come to page 48. Can my learned friend say anything? Kindly come to page 48. He has asked for a new meter and the court has granted him. He did not follow it up. He went on using the commercial meter from
that's because your client didn't give him.
Exactly, my lord.
No, my lord, it is not
Therefore,
required.
he had to go to his own premises.
My lords
and
have always laid down that even a trespasser is entitled to a meter. My no objection is not required.
You have physically restrained.
Can it be physically restrained?
Kindly, your
But
lordship.
after the order of High
This
Court, can I
last
restrain
one,
it?
Last one order. I tell
Kindly-
your lordship.
Lord,
Kindly have a look at
But
the
one
remarks.
second. Lord, kindly
Learned friend made a
takes
false
at page
statement,
48.
then made a application for recalling and then came
Lord,
before
that
lordship.
comes much
we
later.
will hold that he has got no locus standi.
No, that's the one aspect, your lordship.
We will hold that he has got no locus standi.
Yes.
Yet we will pass an
Yes,
order
Lord, kindly.
against the board. You take it on appeal to Supreme Court.
No, my lord, I need not. I'm before
So
you also
therefore,
need not.
sir, from ever since you established the restaurant, probably you are drawing electricity from there.
Yes.
It probably didn't come to their notice. Somebody put the spanner into it. Probably his
I
client.
started,
He
yes.
put the spanner. They made inspection. At least there is a record to show from 2020, this arrangement is going. So therefore, they need to take a pragmatic stand in the matter.
My lord, that's kindly at the cost
They
of
will hear you.
No, kindly at the cost of reputation. My lord, kindly will look at the documents. Your lordships at page, the last documents, your lordships refer to page 200. If I'm not
240.
wrong. 200.
24.
My lord, 24.
220.
Kindly have a look at the date.
Yes.
Does it make any difference considering the pandemic period.
That is different. If they make.
That's then what, why should your losses exercise your losses jurisdiction? For 10 days, for 15 days?
No, the concept,
That's your loss. It covers the entire period.
Cannot be premium on impropriety.
It's not a premium on impropriety.
They are seeking
Kindly,
premium on
your losses do
impropriety.
not do that. It's not a premium on
It's a
impropriety.
violation of conditions, sir. It's a violation of condition. Which will lead to the disconnection of the commercial connection.
Yes.
Malad, disconnection of, I tell your losses, disconnection of commercial connection, your losses lead to that. Malad, in case of any this is only malad side by side two premises that your losses can take.
This will give premium.
But ultimately, when the authorities found that really there is no loss, they cannot do it. They should not do it. That's they have done.
Absolutely.
But your losses probably would not find everything in the order of the final assessment.
5 days. is
Kindly, your
absolutely
losses
arbitrary.
consider the date 3rd March 2020.
But thereafter, we never.
Just a minute.
Kindly
Your losses
see
when the
how they are
pandemic
citing.
situation started.
Fine it.
Now, when malad, we started the business, this is the malad, the
You know,
appropriate order.
All the business have started. Just come back with affidavits.
No.
All this without affidavit,
But whose affidavit? I have not.
without affidavit being.
Well, let affidavit with yes.
যে কথা বলেছে লোকাস ছাড়া
Let's kindly consider the malad point of
That-
enhancement of cost, my lord. Because I am being harassed like at the hands there. Kindly consider the
Fine,
Saleh
fine.
Bharati
Judgment.
judgment.
Judgment reserved.
We have complied whatever the authorities said, we have paid the amount also.
All right. Your client is a powerful person.
Malad, because-
Your client is a very powerful.
No,
person.
it's a small, malad, I tell you,
everybody.
losses, I appear for sometimes for the licensee. If in a commercial consumer is there, if there is no loss, there is no theft, there is no ransom, normally they do not.
This is
But
premium.
that's,
on impropriety.
it's not
No,
a
no.
premium.
No, no.
And considering the facts of the present case.
A commercial connection or a commercial consumer has to be put on more stringent terms than a domestic consumer.
Malad, I tell you, losses, in the city of Calcutta,
Oh, yeah.
malad, sometimes your losses will find, this is my restaurant and this is my room. This is just like this. Malad, there are, find your losses, Chinese hotels in the Calcutta city area. This is like this. I
It is
just
not
consider
like that.
example. Malad, if I take domestic supply and run it, I will be
You will
charging with
penalize.
huge cost. Now, if I take a commercial connection, here restaurant, here I am reside. License.
He
is
had
not
been
considered.
hooking in a naked manner,
That's the situation.
putting
If
the
I do
entire
it, your
property at
No
stake.
problem. Only distinction is if they are.
only the premises number, and that's your losses. For that, your losses.
Two
How am I
different
running
owners,
in this
two
affected?
different owners. He had been
I'm
carrying on
putting,
naked,
how am I-
naked
except
wiring,
Putting a spanner
naked
on me so that I
commercial
can leave
wiring.
the premises.
naked commercial
That's
wiring
the
for
only-
20 years. He has been doing that, and he has been
No objection.
and he has been malad, keeping all the authorities in good terms. That is what is going on.
Probably Tibetan food is very.
Yes, I believe so. If-
Tibetan food is very tasty.
Problem and Lanathan, that's also taken.
The landlord is deprived from that.
Ah, yes.
I'm highly diabetic. I am highly diabetic
has
and
been
aged.
throttled by the private respondent as well as by.
I am highly
You are caught in between.
But I,
This is the
but I have
situation.
not been favored with
Lordship
Malak.
kindly appreciate.
It's clearly tasty food.
Actually, I don't know about your regulation. If suppose a lawyer has his chambers or office in his residence,
Lordship.
whether the connection is treated as commercial or residential.
Malak, kindly do not raise this. After the Malak Supreme Court filed before your lordships, I appeared against the licensee, I succeeded.
Yes.
For one of my brothers. Now the view, I don't know, Malak, after the Delhi Municipal Corporation judgment, initially the view was that it should not be.
But it should not be
Initially.
commercial. Yes.
I, the first matter moved before the Honorable Justice Satyabrat Sinha, requested, please, Mr. Sana, look, this is your brother. Don't treat it as a noble profession. That's the views. Now, after the Delhi Municipal Corporation judgment of the Supreme Court, now this is commercial. Kindly
Yes.
do not touch it, your lordship.
It is commercial.
Everybody will be ultimate sufferer, Lordship.
But I am personally paying commercial charge.
That's the thing. But now this has to be, my lord, considered, an appeal is pending before your lordships. Now this depends upon. Now depends upon if lordship is a complex. Suppose your lordships, if the entire flat is used for the commercial purpose, Then, my lord, this is one thing. Now, suppose, my lord, I decide I have only one flat, I have 4 lawyers. 1 room, 2 room I'm residing. 1 is chamber. Am I to pay for commercial rent?
I was paying commercial
That's not
before 2009, almost 11 years.
the views from the earlier. It's a noble profession. It's not a trade. Therefore, there should not be commercial. That's the views, my lord.
That's why no GST also.
Yes, next.
My lord, I have not used, my lord, because kindly consider that because the lockdown.
Next.
Serial number 7.
Yes, serial number 7.
May it please your lordship, my lord.
Yes, sir.
2 things involved. One is, my lord, want to leave to appeal because my client was not a party to the proceeding in which judgment was delivered. But he was in vital interest. He made a separate application which was not covered by this. 15 writ petitions on a same point has been disposed of by one judgment, that's Bosak. Secondly, my lord, we waited. And that's what the appeal was filed by those 15 writ petitioners. And appeal was pending. And we thought if the appeal has been set aside, my matter is going. Because my application will be purely covered by the judgment. I have single way no chance. But unfortunately, we came to know only given the date, this appeal filed by these 15 writ petitioners were allowed to be dismissed for default last year. So, I have made 2 applications. One is for leave to appeal. Second is for condemnation of delay from the date of
Yes.
the 2 appeals.
Once leave is
2
granted,
applications. Equal defied delay is not
how is the appellant aggrieved by this order?
okay. Is all that now tell you arise out of off license of liquor of license. But my client and others also were given off license under Rule 4Q of the West Bengal Excise rules. Within 9 days, so when my client is concerned, within 9 days of the license, when I set up the wine shop, taken the shop on rent, etc., within 9 days thereafter, Excise Commissioner suspended my license. On the ground, the general election is forthcoming. And as the order says, that we directed by the election commissioner to suspend it. But my client believed in that. When the election was over, then he wanted to continue, thought suspension be taken off. Then, my lord, what are the executive authorities? They repealed Rule 4Q. And we applied for the extension of at least for days we have lost. License is temporary, always. 6 months license given. But really, my lord, as a judgment also, nobody would take the license and make such huge investment for 6 months only. So there is a right given by the Excise Act and the rules to apply for renewal. And right of refusal of renewal is circumscribed. That good grounds have to be there. Anyway, my lord, we suspended, we applied for then a batch of these petitions filed challenging the repeal of Rule 4Q and the non-refusal of gun license. Election Commission order was challenged also. There is no order, election order is not there. Suspension order was challenged. Now, my lord, repeal of 4Q does not really affect me because license already granted under provision. If the provision is repealed, the things done are saved. And if I am ordinary license holder, I shall apply for renewal in terms of excise rules. That judgment made by several petitions, several petitions filed with several license holders for saying that we have lost so many days, make up those days, except for those periods or which have lost. The petition was dismissed by a single bench, Justice Basa. A batch of 15 these petitions were dismissed. My petition was not there, is waiting. And that judgment of Justice Bosak, appeal was preferred by all those 15 persons. That appeal has been allowed to be dismissed
Now,
or
what
default.
happened to your petition, the appellant's petition?
Mine. Like same point. Point is same.
Pending.
Pending.
My appeal is pending, in pending.
So
Pending.
that writ petition can be clubbed along with this appeal.
Yes, 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 that's right. That's right.
So therefore, if you file we grant you leave to file appeal,
By condemnation of delay, others will not leave.
then
They
who
will
appears for the respondent? They should
They
be
will
served.
serve.
Yes, out. Yes, after.
This is available service.
Private respondent, state has
They could.
No, we'll grant leave. Let the council appear and
Yeah,
then
they
we'll
also.
consider the condemnation of delay.
So Mukherjee, you appeared in those batch of matters.
Long ago.
There's commission
So
and
long
real
ago.
party.
But what we suppose.
May I give a copy of the petition? Milord?
All right. Suppose 4Q, repealing of 4Q does not
Doesn't-
really affect.
I'm not.
Then what is the relief you want in the writ petition?
Mine would be, Milord, that my license has been suspended. I've been allowed to use license only for 9 days. Therefore, Milord, I should be extended for remaining, let us say, 5 months and such date. Then I have a right to. I have a right to apply for renewal under excise rules. We shall apply there under, and they will consider. They will consider whether.
Oh, they are not required.
They are not required.
Actually, sir, if suppose you are not able to enjoy the license for reasons not attributable to the licensee, you can seek for remission. That period.
That's exactly what we're praying.
Remission you can seek for. That
Seek
is what.
for the period of suspension we're praying.
Remission you can seek for not operating the license.
That's right.
The other remedy is for renewal is a separate remedy.
Second, Milord, we shall have a right to apply in accordance with law. If the law permits, we shall get this renewal. That's a twofold.
But we can't issue a mandamus to extend the period of license.
No.
Because same issues are came
Well,
up
well,
before
release
Supreme-
or also mold according to what the council.
Because
But this period have been suspended unnecessary. That also can be considered how to make it up. And also may only have a right to apply in accordance with law.
in fact, there are a lot of judgments of the Supreme Court in mining cases where there may be a force majeure or vis majeure condition which prevents the licensee to excavate minerals or operate his license. There may be other conditions where the government for some probe in coal mining also they'll say stop mining activities. Then after all the investigation, they'll say nothing is wrong with you, you can continue. What happened to the period lost? So the issue was before Supreme Court whether extension can be granted. There are one set of the decisions which says yes, this condition he was not allowed to operate. Therefore, for 2.5 months they may consider. The other one, the Supreme Court says no. We are not here to extend the license condition. If it is a lease, it is a different matter under the MMRD Act. License, he can seek for remission for that period. Proportionately, you divide the license fee.
Yes.
For 3 months, I am not able to operate, deduct that. And sometimes the government may take, all right, instead of deducting that and paying you, you operate it for another 3 months.
The remission, but that really my lord said that my client should apply for that.
All right, first we'll grant leave to file appeal.
There are 100 matters of same kind. Some of the matters I appeared, my lord. There are 2 batches matters, my lord. One batch of matters, my lord, Justice Devanshu was dismissed. Another batch of matters filed before Justice Rajashekar Mantha, my lord. He, my lord, dismissed the matter, but liberty has been given to, my lord, whenever, my lord, there is a, my lord, under the other sub rules of the, my lord, rule 4, my lord, whenever, my lord, the state will, my lord, advertise, they have the first my lord, liberty to apply, my lord, to that
preference.
Preference, my lord. That is the judgment, my lord.
Now you are not advertising at all.
No, my lord. There is no, my lord.
No,
that is the, my lord.
Justice Mantha's order, I know it.
That is
Order was, you can apply for the issue of
Or what we
license.
can do is we'll let Mr. Mukherjee take notice. Let him get instruction. So 200 matters means
100, more than 100 matters. There are 400 licenses all over West Bengal.
But we can't, what do you say, direct them to issue a license. Especially that the nature of trade Res
entire
extra
batch can be
commercial.
disposed of. Same point, law will be involved.
My lord, what fallen from your lordship, there's a mining lease. In a mining lease, your lordship knows some rights are accrued, but in a, my lord, in a
Subsoil rights.
trade in liquor, my lord, there's no right has been, my lord, accrued, my lord. There's a, my lord,
No,
a
no,
settled
no, no,
principle
I'm
of
not
law.
saying that. That is a mistake, economy. But there's a difference between right to get a license and a license holder right to carry on business. This is legal. That's it. I am second category. I've been granted the license. They have a legal right to carry on business under the license. And Milord, those judgments who relied upon Justice Batsag, Milord, the whole judgment applying obtaining license, that was refused. Policies that some states are dry, have become the policy is dry. Our state is not dry.
You get instruction in the matter. So for the so and so Mr. and senior advocate. We directed Mr. We have directed Mr. Mukherjee and Mr. Debashish Ghosh, learned advocates for the state to accept notice for the respondent. The learned advocates have prayed for time to get instruction in the matter. So how much time you will require?
But after vacation, any day, my lord. Vacation now only 1 week after, my lord.
All right.
Labor after
6th
vacation.
June.
What?
6th June.
6th June.
Tuesday. Oh, sorry. 7th June. 7th June in the same position.
Milor's are direct.
Delay be condoned, Milord. So that delay.
No,
Be
let him first get an instruction. Delay and leave all can be granted.
granted.
This is only a technical delay.
It is right.
So
At
once
one
we
point
grant
of
leave
decide.
to appeal, because other people have forgone the.
No, I have indicated the point I shall argue. I am not a license seeker. I've got a license already.
Subject to correction, my lord, to my senior, my lord. There are categories of licenses under, my lord, the Excise Act, my lord. My lord, first of, my lord, the provisional license. If there is a, my lord, after advertisement, there is a provisional license, then, my lord, the permanent license. My lord, those are judgments, my lord, during the, my lord, provisional license, there is no right accrued, my lord. Then, my lord, when the permanent license comes, my lord.
During provisional
There's
license.
nothing called permanent license. All licenses renewable. Nothing called every year they are renewed.
I will satisfy. And get some notes.
My lords have been pleased to direct the writ petition to appear together with the.
Which one?
My lord, my writ petition which is pending, which.
That we'll see on the next day.
And my lord, there's an appeal pending from the order of Justice Mantha, which was just referred to. That is item number 828 of the monthly list. If that can be tagged along with this.
828 along with this, item 820.
Grateful.
Serial number 8.
Please tell her.
The other advocates may not know about this.
Will serve, my lord. Will serve. This is appearing for the first time. That appeal will also appear.
No,
800 will not be knowing that their matter is being clubbed with this.
We will intimate, my lord. We'll intimate. It's appearing on 6th of June.
Should I keep a paper book ready?
No, I think documents are here.
There. And can it die?
Notice if they are
they
appear on that date, we can take up that matter along with.
The problem is they have got some limited relief in that. If they are not aggrieved by that portion, they will oppose clubbing this.
My lord, we are only the same set of appellants and the advocates are the same.
Advocates are same.
Same.
Only direct my advocate to serve copy of my writ petition upon the respondent.
Yes.
Right?
The learned advocate for the appellant is directed to serve copy of the writ petition along with the annexures
and the affidavit of which
to the learned advocates appearing for the state. Next.
Serial number 8. May it be Lordship, Lord, I'm appearing for the appellants. Lord, this is against an order was passed on 13th of April, rejecting my writ petition. But the facts are not disputed and very small facts, not short facts. The appellant had taken loan from State Bank of India. But substantial payments were made. In 2020, there was an OTS scheme. We paid, during Corona period, we paid more than 2 crores. Thereafter, my lord, we were not able to pay. In October 2021, Corona had almost ended. We approached them that during Corona, we have paid more than 2 crores. We were not able to pay.
kindly accept 6.5 crores in full and settlement. Corona has ended, will be able to pay within a particular period. Not 10th of January 2022, our request was granted. OTS settlement was approved with a time particular schedule. But I'll come to the terms. But immediately after we received the letter, there was an attack of corona variant, that Delta variant, Omicron variant. For 2 months, situation was worse than even before. We were not able to pay. The last date for payment was 31st of August. But it was to be paid in installments. I'll come to the facts. In 5th of May, they issued a letter cancelling the OTS. In July, we sent a letter that corona has eased. Last date for payment is 31st of August. We will pay the entire amount before 31st of August. It was not allowed. Then we came across a judgment, unreported judgment of the Supreme Court, where it said that if OTS is there, if because of corona one is not able to pay, court can extend it. High Court in the writ jurisdiction had refused to extend it. Supreme Court said, yes, it can be done. On that basis, we filed the writ. There are few facts more, will come afterwards. We filed the writ petition. Relied on, it was an unreported judgment. We have annexed it to our writ petition, If your lordship would kindly, come, page 196. Unreported judgment of the Honorable Supreme Court.
But very recently, there is another judgment. South Indian Bank. There is very recently a two-judge bench of the Honorable Supreme Court, led by Justice M.R.
Yes, after this.
17th April.
Yes. But that was a judgment. I have,
and
that is a case. I have brought it. Arvindra Electronics, State Bank of India versus Arvindra Electronics.
No, it is South Indian Bank versus something, very recent judgment for April, where the court says that don't interfere in all these matters. You are nobody to extend the time for settlement.
I go down to that proposition.
This is on the peculiar facts of the case.
Yes. Please.
If I may say the name of the judgment, it's Phoenix R, where it is very clearly stated that.
No, South Indian Bank versus something.
Yes. And
You take it out. Where is your iPad? You're not carrying an iPad. You're not carrying a mobile phone.
Yes, I am.
She should have a slot, right? But at my age, I'm not supposed to carry this.
No, sir. The age is not at all.
But I'm not 74. I never learned these things in my school and college days.
No. In fact, if you start using it, you will be better off than people of half your age. It's all that. It's only a mental block. Once we get accustomed,
I may not go down.
Now, what do you want? Now, no settlement. Bank is refusing.
Only thing what happening. I have here, all the decisions. There is a very important distinguishing factor that in those cases, extension was sought for after lapse of the period. In our case, no. If your lordship will.
So, if they have already issued 13-2, 13.
No, not only 13-2, 13-4 has not been issued.
So wait till 13-4. You challenge it before the DRT. Before the DRT, you file a miscellaneous application. Sir, this is my contact. I said by 31-8 I'll do it. But in May they cancel my OTS. Even now I am ready to do. Please step up additional 50,000.
But that is not undoubtedly not. But kindly, hear me for a few minutes.
No, sir. Supreme Court says don't.
No, may I.
And a similar relief, we have 2 weeks back, we have dismissed 4 appeals.
May I come back on Monday after seeing that judgment? Kindly keep it close. But let me.
We will grant you liberty to approach the bank.
Kindly, pass this order on Monday. Lord, Friday holiday, my lord. Let me, my lord, try my luck on Monday, my lord. Let me come across, my lord, from
Which-
South India.
Tells the borrower who has not made payment as per sanction. So
Yes, my lord. Even, my lord, I have,
Cannot
there is a
change this.
judgment, my lord, earlier judgment on which the learned judge has.
no, it won't make a difference, sir.
My lord,
Unless-
my lord, at least for my satisfaction, Lord, kindly take it up on Monday.
No, what we'll say is, so far as the law on the subject is concerned, nobody can dispute. But nevertheless, the conduct of the borrower can always be examined.
Yes,
Suppose they have transferred the asset to a reconstruction company. The matter goes out of their hand.
My lord, kindly take it up on Monday, my lord. Can give me 10 minutes time on Monday, my lord. At least, my lord, I'll have satisfaction.
the
I have tried my best.
Only problem is, sir, when next Wednesday when it comes,
Next Wednesday, my lord.
we can't guarantee where the matter will come.
My lord, what will I'll try, my lord.
It
I'm
will
not
be-
praying for an interim order today. Let me try.
My learned friend has given this judgment.
Ah.
This is South Indian Bank
Ah.
versus Naveen Matthew Philip and another.
You should be carrying.
Reported at SCC online Super SC 435
Ah.
2023.
And please
My
share
lord,
it.
here, my lord, in that case, I'm told by my yeah, the writ petition was filed after 13/4 and it was held, it is not maintainable.
That is correct. If you see the last 5 or 7 paragraphs, they have extracted all the decisions of Supreme Court and says when there is remedy provided, it is not as if you are not.
Remedy, my lord, at the 13/2 stage. My lord, there is.
Not-
My lord, here, my lord,
After we have elaborately heard the learned
Sir,
advocate.
kindly, my lord, can you keep it on Wednesday, my lord?
Yes.
I'll try my luck, my lord, if it
Ah.
Your Lordship, if I may add just one thing, that this judgment was again talked about in another judgment called Phoenix Art versus Vishwa Bharati, where it is very clearly stated.
That is the later view.
Yes, this judgment has been.
Next,
If I
next-
keep copy-
No, not required. Next
My
hearing.
lord, I'll make some advance
It's a
orders
settled
and
law, your
observations have been made, my lord. I'll make my submission, but kindly give me 10 minutes time, my lord, next week.
We have heard the
Just
elaborate.
one more addition.
We have 1 second, please. We have elaborately heard the submissions of the learned advocate for the appellant. And we are of the prime facie view that the writ petition for the relief sought for was not maintainable. And the learned single bench was right in dismissing the writ petition. However, the learned, at the request of the learned advocate for the appellant, we adjourn the matter. List the matter on next Wednesday.
Your Lordship, I'll just make 2 submissions. That we are respondent number 5. We were not the party in the.
Who are you?
I'm the asset reconstruction
Oh.
firm. And the second thing, your Lordship, it's very clear we are a private party. And the second law is that when the effective remedy is available, the High Court does
You
not
support the bank. You support the bank.
supporting the bank.
So
And
we-
we don't- and they have not filed any.
What have
further
you done?
application.
What have you done to recover the money after you got the
But,
asset?
Lord, during the pendency of the writ petition, after the judgment was reserved, it was assigned. So, my lord, list pendants.
So we were not the party and now
Not
they
because
have
we
made
were
the
not
party, but
parties.
we will not
In
get into
order
the
to
fact
make
because
our,
it is not maintainable
it
against.
is,
Very well, Lordship will
other-
come back on Wednesday, Lordship.
not ours, they try to make the writ petition infructuous. After assigning it, after the judgment was reserved.
Next.
Serial number 9.
But I pay for the respondent.
Lord, before your Lordship, Lord, looks into the impugned judgment, may I just briefly tell your Lordships what the facts are? Lord, there was a tender floated for the purpose of maintenance of 2 underpasses. One is the Beliaghata underpass, the other is Swabhumi underpass. There are 2 underpasses which I have to maintain, rather the contractor has to maintain. Now, Lord, the terms of the tender said that I have to pay a license fee, then Lord, I have to maintain, but to recover the revenue, I'll be given 7 hoarding sites, out of which I will recover my revenue. And the contract would be for 10 years. This contract was concluded in October 2022. Now, Lord, after that, there are 3 letters which I want your Lordships to consider before I take your Lordships to the judgment. Lord, the first letter is at page 245.
in a concluded contract, after the contract is concluded, this is the first letter which is received, and I was discharging the function, Lord, as a contractor. Says KMDA was the custodian for the maintenance of EM bypass. The contract was granted, Lord, the concluded contract is between me and KMDA. Connecting the northern and southern part of the city and starts from northern hub, Ultodanga to Goria in the south. The road length is 15.6 kilometers, which runs along the eastern ring of the city. After careful consideration, it has been decided that the maintenance of the road along with drainage be handed over from KMDA to KMC. This is not an order issued by the Government of West Bengal Urban Development Department. The defects, carriageway, etc., etc. That's not important. What is shown is, Lord, that this portion of the road, this 15.6 kilometers, is handed over from KMDA to KMC. So, Lord, let us say there is a change of ownership in respect of a portion of which is the underpass. And Lord, there is a concluded contract which is continuing. Now, Lord, please come to the next letter, which is at page 241. Lord, before that, I write, my junior rightly points out, kindly come to page 245. Kindly see, Lord, 4 and 5. 4 says the right of collecting revenue from the advertisement display will remain with KMDA. All the structures as the new and old bridges, culverts, etc. will under the custody of KMDA. So, Lord, so far as the hoardings are concerned and displays, that still remains with KMDA. Then, Lord, please come to page 241.
Yes.
241, the letter on the 24th of January 2023. It says, with reference to the above and as instructed by the competent authority of KMDA, keeping in view of the recent change scenario of handing over of the maintenance of EM bypass to KMC for KMDA, you are requested to stop all kinds of site activities with immediate effect till further notice. So, Lord, this is issued by KMDA. Now, Lord, I challenge this in a writ petition. During the pendency of that writ petition, another order is issued terminating the contract on 7th of February 2023, which is at page 254.
Yes.
It says the cited tender is hereby cancelled by the authority in KMDA. We would state that the regret that the tender has been found having technical fault, non-specific, not well defined, thus creating ambiguity for obvious reasons. By this, the authority is incurring financial loss as well. We regret for the inconvenience caused to you and are hereby to reimburse the cost you have so far incurred in the work. This has been decided in the license that the license fee deposited by you and the cost incurred for construction activity and maintenance work would be refunded as per actual assessment of the divisional engineers based upon the approved drawings and execution. Now, Lord, this is what is challenged because, Lord, writ petition.
2 writ petitions.
The second writ petition was heard because, Lord, first writ petition became infructuous because the stop work has really, Lord, merged into the final order of termination. Now, Lord, this is what was the subject matter of the writ petition. The basic point which we raised are that, Lord, by change of ownership in respect of the road, the right to collect revenue remained with the KMDA even after change of ownership. But that change of ownership could not have warranted, Lord, termination of a contract. Our second point was that concluded contract has a termination clause, and it says only if there is a breach. That breach, I will be given a chance to remedy, and after that, the contract can be terminated. But this was also, Lord, a point taken. My third point was that in any event, the terms of a tender has merged into the contract. What is terminated is the tender, not the contract. So therefore, Lord, the contract survives. If your Lordship kindly sees, it says, by this reason, kindly see the first paragraph, last sentence. Oh, sorry, the cited tender hereby cancelled.
First line.
So, my lord, what is cancelled? Because, my lord, the contract, concluded contract cannot be terminated, my lord, unilaterally.
During pendency, you had an interim order, writ petition.
No interim order because, my lord, the learned judge, my lord, disposed of the writ petition at the first instance. My lord, without direction for filing affidavits. Point of maintainability was raised, and my lord, that was being heard along with the merit. So, my lord, now kindly have a look at the impugned judgment. Please come to paragraph 4, internal page 3 of the judgment. If your lordships are looking at the judgment from the
memorandum, please.
Kindly come to paragraph 4. The controversy in the present writ petition rests on the letter of KMDA dated 7th February 2023. This is page 254, your lordship has seen, by which the work tender given to the petitioner was cancelled. The reason given for impugned cancellation is that the tender has been found to be technical fault, non-specific, not well defined, thus creating ambiguity of obvious reasons. The other reason given is that the authority is incurring financial loss as a result of the tender. The letter of cancellation was preceded by a letter of 24th January 2023. This is page 241 from KMDA to the petitioner requesting the petitioner to stop all kinds of site activities with immediate effect until further notice. The reason given for the stop work request is of a change scenario of maintenance activity of EM bypass being handed over from KMDA to KMC. The reason given for stop work would also be evident from an order dated 1st December 2022, Urban Development Municipal Affairs Department, Government of West Bengal, which states that the maintenance of the EM bypass, which connects the northern and southern parts of the city of Kolkata, starting from Ultodanga to Goria and running around the eastern ring of the city, will be handed over from KMDA to KMC, including certain activities mentioned in the order. Then, Lord, please come to paragraph 9. The court, Lord, raises two questions. Thus, the question which must first be answered on the preliminary objection raised by the respondent is whether the writ of mandamus can be issued against the respondent KMDA for not enforcing its contractual obligations. But that is not, Lord, posed a wrong question, because that is not the issue before in the writ petition. Writ petition is that you have terminated. You have terminated tender, not the contract. Number one. Let us say you have terminated the contract. Even then, whether on those grounds, because these are extraneous grounds. Lord, it says the grounds are, Lord, non-specific tender, not well-defined tender, thus creating ambiguity for obvious reasons. Lord, what is the obvious reasons, Lord, for ambiguity? Because there are two underpasses. The parties who negotiated during the tender process with 50 pages of tender document, NIT, everybody understood what the work is. I have to do the work of cleaning, maintaining the underpass. And it is clearly stated in the NIT. And Lord, I will be incurring cost of payment of license fee, which was negotiated with them, and they fixed the license fee. And Lord, I will recover it out of 7 hoardings, which are approved. If your lordships kindly sees these 7 hoardings, the sites are approved. If your lordships please.
Yes. We saw the photo.
246 onwards, your lordships will find that these are the sites, and 221. Your lordships will find that it is approved and signed by KMDA. 221 onwards, there are 7 sites. Which are the sites, location, everything is approved. Where is the question of any ambiguity? And Lord, these are the 2 questions that the court framed.
Come back after 7 months of tender.
Lord, this is after 7 months of the tender.
Started working.
221 to 227, your lordships will find those 7 spots are approved spots. The authority has approved these spots. And then, Lord, after posing
no, all these are lying idle.
Yes. The point is, Lord, because of the termination, I will be facing, Lord, a breach of contract with those sites, because I have let out in turn, Lord, these sites. However, Lord, my 10-year contract has been terminated, not for breach, but for, Lord, these extraneous reasons. Lord, I have a lease. Lord, I put this question to myself. I have a lease.
All right, we'll entertain your appeal. We'll hear it out. When to hear?
Lord, any day that is convenient to a lordship, because
who's maintaining the underpass?
Lord, we were maintaining it until termination. After termination, Lord, obviously we
still maintain.
we are still. My instruction is that we are still maintaining it.
Veliagata is not maintained.
So this is not maintained because of this, this stuff?
No.
Oh, I see.
Earlier also.
No, but this is October, Lord. We started working.
I came here in October last.
But after that, 22. Then Lord, I don't.
Not maintained. Because when you take a walk, it's quite safe.
Yes, to go take down.
You go inside.
Yes.
It's very safe roaming here and there. Because EM bypass, it's not safe. Though there is a barricading.
No, but
this side along the stadium is safe. So I used to go underneath.
I see.
Not maintained. But these hoardings are lying. Vantage point, especially the Chingrigata junction, it's a huge one. And that will be a traffic hazard. Definitely it will be. Because with this LED hoarding, immediately the driver's reaction is.
But this termination, Lord, luckily for me, does not take that ground.
That's the problem. If it's a normal hoarding, is right. Suddenly you say Sachin Tendulkar.
I can understand. They are saying that you have to replace the hoardings or take the hoardings out of the location, etc. But Lord, where is the question of any ambiguity in a contract for?
But under the whatever notice inviting tender, etc., what is the remedy available? The learned judge appears to have non-suited on the ground of
yes, because she says that this is a private law remedy, and therefore your remedy does not lie in writ court. But Lord, the learned judge has ignored Lord MP power, which is the recent judgment of the Supreme Court, where the Supreme Court says that even in a private law remedy, when there is a violation of Article 14, then Lord, the courts can entertain a writ petition. Lord, if I file a suit, Lord, it will take Lord 10 years. I won't be able to Lord do anything with regard to that. And my question of damages, I'll have to prove how much profit I would have made for 10 years and all that. This is a contract for 10 years and unilateral termination, not on the ground of.
All right. Now, suppose you are still maintaining. Who's paying you?
Nobody is paying. Nobody is paying. Nobody is paying. Lord.
No, of course, there's no payment. You have to earn through the hoarding.
I have to earn through the hoarding. I have paid my license fee for this year. Now it's a question of recovery.
They are ready to refund. That's what they say.
Yes, but a refund will not only with regard to my cost. What happens to my profit for 10 years? That for that plot, I will have to file a suit.
ইলেকট্রোমেকানিক্যাল এর জন্য টেন্ডার বার করে দিয়েছে
Sir, in the interregnum, who will maintain the underpasses?
Lord, my immediate instruction was when your lordships were dilating, that now the possession has been taken over by KMD. Therefore, whatever maintenance will be done by us.
But their major point appears to be after the contract, the notice inviting tender matured into a contract. How do you cancel the tender notification?
Milord, please have a look to that letter. Milord, yes, it appears to be some ambiguity, but Milord, legally, Milord, there is no problem in my very respectful submission. Please come back to page 254.
Yes.
Please take the subject of that letter. Cancellation of work stroke tender. Again, Milord, not very happily worded, but
yes, that's what we are discussing.
Yes.
It's not happily worded.
Yes. So we have cancelled the work. It's not the tender.
Because you can cancel the work for defaults committed by the successful tenderer in terms of the agreement, wherever the agreement provides for.
Yes.
Suppose he brings it into and there is an arbitration clause or some alternate mechanism available, he can always examine. But it says tender have been found to have technical fault.
Yes.
Non-specific. No, it's a tender. Terms of the tender. Non-specific, not well defined, creating ambiguity for obvious reasons.
Yes.
That's where the catch is.
Yes. Now, Milord, I'll tell you this. I'll tell you, Lordship, why. Milord, he was supposed to, Milord, maintain the underpasses, and in return thereof, Milord, he was, I mean, my learned friend's client was to put up hoardings Milord, in the underpass.
Inside the underpass.
Inside the underpass. Now, what happened is, because of, Milord, inarticulation, Milord, in the language, he has put all the advertisement, Milord, on the outside.
Chingrigata Junction is a huge hoarding. Just
This
they've
is,
got that, what is it?
That flyover, we pass under the flyover.
No, front.
No, beside that water body.
After that, what is it? Captain Berry. Captain Berry.
Yes, that Berry.
And the road takes a turn.
Right.
And you take the flyover to go to Newton.
Right.
You go straight. On the right side is this
yes,
huge one. There is a, what is the escalator, I think.
Yes,
for the people, newly constructed escalator. Huge one. I used to wonder if, suppose they start playing some advertisement. The traffic will come to a standstill.
Milord, my learned friend's clients has not been licensed that area. That is not the area.
The photo, this.
Kindly come to page 221.
These are, Milord, on the bypass.
No. Please see this. I just now saw that photograph. Every day I'm going that same. What else I'll do?
Milord, if my lord is looking at Milord.
226 or 227?
It must be 221.
221.
Milord,
221. Are you able to see the escalator with the
yes,
blue cover?
yes, it is Milord between. This one is just after that Chingrigata flyover that we go down,
right.
And thereafter this part comes Milord on the left side, left to right side.
Huge one.
Huge one. But it is just crossing Chingrigata.
But there is other. Do you find him otherwise to be a very bad person?
No, the situation is otherwise. Their stand is.
No, if you're not supposed to erect hoardings on the road.
That's not the ground. I understand. Then, Lord, it is a breach of contract. This is the approval they have given.
No, probably if we see the file, kindly court, if suppose the court is prima facie satisfied, let us see the decision-making process.
Yes.
254 may not be happily worded.
Correct.
But the basis for 254, if in the file it is shown that you have violated the terms and conditions, then
probably I concede to that. 211. Can you please come to page 211? Why the stop work was issued? Sorry, stop work. Oh, stop work.
241.
241. Kindly come to 241. Why the stop work was issued? Kindly see.
Recent change scenario of maintenance, handing over of maintenance. That's the only reason.
Only reason. Transfer from KMDA to KMC. Lord, I am a licensee or a lessee in respect of a property. The owner, Lord, transfers the property, Lord, to somebody else. The two doesn't match.
They won't maintain. Sir, one suggestion. Ultimately, even we uphold the order because the law says yes. The learned judge says hands-off approach. Quite so.
Right.
But ultimately, the sufferer is the common man, the public.
Yes.
Because with your infrastructure, you cannot maintain. You cannot maintain. What you will do is you will outsource it. You will outsource it to a contractor. So the maintenance work has to at least start at 12 p.m. in the night, carry it out on all 4-5 directions. And you got the other one, Swarnabhumi, the other underpass is also there. So, at least the cleaning should take place twice in a day. The moment a train or a bus comes and halts, there are hundreds and thousands of people going in and going out. And you know what sort of nuisance they'll cause. So technically you may succeed, but ultimately what will happen if the reason for suspending work was change of ownership or handing over? Is there any possibility of some sort of a mediation or discussion?
Milord, please have a look to the report that we had filed before the court, which will on affidavit, which your lordship would find that from page 258.
Very damaging, is it?
For him. For his client, and not for him. I'm sorry.
So, Milord, please take me at page 260. First is granted license and paragraph A, including upkeep of the underpass, progress, garden area at the underpass. Then B is very important. As per NIT, 250 square meter inside and outside area was let out at the underpass for commercial advertisement. As per the terms of NIT, KMD allowed petitioner to put up advertisements at the underpass. Then D, it transpired later that the petitioner did not put up advertisement boards inside the underpass and utilize the outside locations for putting up the advertisement. Now, this is where, Milord, the public revenue is involved. This is where, Milord, there is an infraction.
Suppose if this can be arbitrated or mediated, and you give him some other offer, you remove these boards, put it inside, or you reduce the period, or give him a remission of the license fee or whatever fee.
As your lordships were pleased to observe, we have told them that we are going to replenish whatever you have incurred.
No, that is as per your assessment.
Yes.
See, by the divisional engineer's assessment.
Yes.
So if he says he has spent 100 rupees, you will give him 10 rupees.
Milord, he is at liberty to, Milord, your lordship gives him that opportunity.
Of course, you are a development authority, being of the government. Even payment of gratuity authorities, etc., they will be able to, in Lok Adalat, we have settled almost 800 to 900 cases. Initially, the managements were a bit apprehensive. The labor lawyers were there, then they participated. Authorities also came. We had excellent results in at least 3 districts. So suppose one round of discussion, if you can somehow.
Milord, discussions can take place. Milord.
No, we are not saying anything on merits.
No.
We give you 2 weeks time. In the meantime, if you can mediate, we can also suggest some name of a mediator. Nothing wrong. No, he is very surprised. Why mediation with the government? Yes, it can happen. Supreme Court says even in an income tax matter, mediation.
Right.
A lot of people think only in matrimonial matters mediation can take place. No, it's not that way.
But I suppose, Lord, if they were having any grievance with regard to my putting up these hoardings,
you remove it.
There was no problem. They should have called me. Lord, the approval, I have not moved an inch from the approval. It is not a case that I have put up hoarding at a place which is not approved. It is they who have approved. Lord, please come to page 211. This is the contract. Work order, part of the work order.
Or we'll just adjourn it. You just have a discussion with the.
Milord, may I in that case, Milord, may I talk to my officers?
Better. You can talk to your chairman or managing director.
So far as my client is concerned, we are open for any reasonable suggestions. And Mr. Dotto is a very, very reasonable.
No,
I don't
my
mind.
reasonability will not work.
No, I'm saying if
you can tell the we can facilitate that process by passing a short order without affecting your rights, subject to.
Let me have a talk to them.
We'll just adjourn it to next Wednesday.
Very good.
So it's better that you resolve it. And so far as the legal issue is concerned, we leave it open, or we can even say that, yes, the law is like this. In contractual matters, please keep your hands off.
Right.
But if he is able to establish absolute arbitrariness, and there is some other bias, etc., total non-application of mind, and one of the contracting parties is a state, then courts have definitely
Yes, the window is not completely closed.
Completely.
There are exceptions, arbitrariness, extraneous considerations are there.
And we have
But,
heard Mr.
but kindly permit me to come back next Thursday,
Next Thursday.
Thursday week.
We have heard Mr. Jaideep Kaur, learned senior advocate, and Mr. Kishore Datta, learned senior advocate for the respondent. At the request, list next Thursday in the same position. Oh, sorry. We'll stop with this, sir. In fact, on one matter, you will be surprised. In a liquor license matter, on my suggestion, mediation took place and it was settled. Imagine the excise department, these fellows will never budge for anything. But there was a private dispute also in between, which led to the first suspension and then cancellation of license. So it was resolved.
But resolution is possible in every possible situation.
And this, I think, he doesn't appear to be a very bad man. That obvious reasons is only bothering. What is the obvious reason? But then if otherwise he has been doing it well and probably
But working for public sector undertakings, these obvious reasons have manifold repercussions.
Specific repercussions. Change of hand from KMDA to KMC should not be a ground for.
Why did you give it off to KMC?
No.
It was hampering public revenue.
They have not
But
given up
I'll tell you
the
that
right to
on the
collect the revenue. That remains with them.
Because KMC is not able to. We were having labor matters. There is only one contractor with them, Delta.
Yes.
What is her name? Amrita Pandey. 100 cases she has got, Delta. Soumya Majmundar will appear. Complete default. He is not registered under the Abolition Act. He has to be prosecuted, but his contract is renewed. So at least thrice we have arrested all those directors, got money out of it. He will come and maintain. He will not send anybody. Yeah, impossible, sir. It's impossible. Unless you outsource it to a good agency who have got good cleaning equipment. Because underpass does not have direct sunlight.
Yes.
As a result of which, there are a lot of issues.
Yes.
But I'm told in foreign countries, they've got this piped sunlight facility. It doesn't percolate the water or anything, but the sunlight comes inside. In the olden days, this tiled roofing, you'll have one glass.
Yes.
So that the light comes in. So KMC can't maintain. From what little we have understood in the pending litigation. They are, first of all, they don't have permanent workforce. All of them are contract laborers. Contractor doesn't pay them. KMC doesn't pay the contractor. Everywhere the problem is. So therefore, you retain as a development authority until this is resolved. You can do that one instead of handing out to. They don't. My opinion. I may be wrong.
So they have not handed over the right to collect the revenue. That
revenue is with me.
But see, because he is technically a development authority.
Yes.
He may not have the infrastructure or a workforce for maintenance.
Not possible.
That's precisely the reason they gave it to you.
Absolute. And they may have given it to others also prior to my contract.
And other places.
They were maintaining.
My lord, I'm paying for one indulgence, my lord.
Sure.
Item number 14, I'm the appellant, my lord. I'm just praying it for not this week. Tomorrow I have.
It will never come this year if you pray, take adjournment.
Tomorrow,
2024 it will come.
no, my lord, tomorrow I have one doctor appointment.
No problem. Tomorrow will it be taken up? Your colleague, nobody can manage.
My lord, I'm the advocate on record. With me, learned ASG will appear, my lord. So
Ask one of your friends, judges are saying, ask one of your friend to come and say that.
You informed the respondent. No.
yes, my lord, I will inform.
What we'll do, let it remain in the list. Tomorrow we will adjourn.
My
You inform the respondent counsel because they'll be. You have to put them on notice. They shouldn't say, we didn't know that you are going to seek for action.
Much obliged.
Much
I'm grateful.